किसका लाइव स्ट्रीम हो रहा है? यूट्यूब पे नहीं है। कस्टम लाइव स्ट्रीमिंग सर्विस पता नहीं क्या नाम आ रहा है। चलिए
my lord,
Yes.
in item 49.
49 yes
We wanted to file an affidavit, my lord. Affidavit is ready, my lord, but they not be signed because the official is suffering from chicken
have
pox.
you informed the
I
other
have informed.
Mr. Gupta, standing counsel, government of India, submit that an affidavit is required to be filed. This is a writ appeal. Why do you
My
need to
lord,
file?
before the single judge, my lord, we have not filed our pleadings.
Okay,
So we have to file.
Is required to file on behalf of the Union of India, and 2 weeks time may be granted for doing the needful.
All right.
List of 2 weeks. Great.
May it please your lordship. Lordship, item 61.
61.
Union of India was supposed to file an affidavit.
61 is Union of India is not there. Yeah, all right. Union of India wants to file an affidavit.
The court had earlier
This is
directed.
a 2018 appeal. What affidavit is required now?
Lordship, at the time of hearing, the lordship may kindly see the order dated 1/8.
So let the file be called out then. Wait the matter to be called out. Wait for the matter.
May I please, your lordship? Your lordship, as regards item number 58, your lordship. Your lordship, in this matter, your lordship, the learned senior counsel, Mr. P.J. Sarkar sir, is appearing, your lordship. Your lordship may not, would like me not to take this matter up, your lordship. Your lordship may not like to take up this matter. Any
List
other
before a
bench?
bench of which Honorable Justice S. Kond is not a member.
Much obliged, your lordship.
May it please your lordship?
Yes,
I have,
please.
lordship, I have filed one additional affidavit today, lordship, in item number 21. An affidavit to bring on record certain documents, lordship, in the, if the,
That's a bunch matters.
in the tender matter, lordship, there is some document,
21,
91, lordship,
9
supplementary list. Certain documents has to be bring on record, lord.
$91. And counsel for the appellant,
Yes, no, lordship, respondent number 5.
respondent number 5 submits that he has filed an affidavit on behalf of such respondent. The other side,
Lordship, it may be allowed to bring it out record today.
oh, you just call the affidavit.
Yes.
Daily list for orders, item 51.
Mr. Nair, what has happened? The nodal officer has not been appointed.
The nodal officer has been appointed.
Okay.
They are communicating now, my lord, and
Okay.
I've been told. I've been trying to collate the information, my lord, and unfortunately I could not. But my friend has said that they have now started digitally signing also.
Okay.
So if that is there, my lord, it's a positive development. My lord, we'll wait for some time.
All
Let's see how
right.
it finally comes out.
Mr. Nair submits that,
Lordship,
yes,
since the all grievance has been mitigated, Lordship, maybe closed, matter may be
so
closed.
let it be pending, let it be pending. Why are you so anxious to have it closed?
Lordship,
Why?
Since the preamble.
So that a new one may be filed on the failure of your officers to do the needful. Let this be a continuing mandamus.
Let there
Let
be
it
a
be.
system first, my lord.
No, first of all, if you are asking for us to close it, then tell us why shouldn't we impose cost on the state? Why the judicial officers were made to run from pillar to post in this case? Tell us then. All right. We'll close it, but with a heavy cost on the government. Your flaws are apparent from what directions we have given over a period of time, right? It is an admitted case. So for causing so much of discomfort to the judicial officers, we'll impose cost of 5 lakhs. Let it be recovered from your CAG. What do you say?
No, Lordship. That is.
Then why are you so anxious? Let it continue. Senior Counsel, Mr. Nair, representing the petitioner, submits that the nodal officer has been appointed and his number has been, and that the petitioner association is regularly communicating with him this court is further informed that the requisite payments are being disbursed or with digital signatures. Let fresh progress report be placed on record for the court's perusal after on the next date of list after 8 weeks.
Lordship.
Or let it be
6
6 weeks.
6 weeks. Much obliged.
Item number 52.
Lordship, I pray that the matter be taken up after some time, Lordship.
My lords, I appear in this matter for the petitioner.
Yes.
My lords, I appear in this matter for the petitioner.
Yes, madam.
My lords, we have filed this petition.
Which item, madam? We have taken up item number 52.
Oh, sorry, I'm apologizing, my lords. 54. Apologies, my lords.
Okay. Pass.
Item number 53.
Lordship, please. My apologies, please. I'm here against the recovery against the possession for my property. I am a legal heir of a property which was actually used as a guarantee by the directors for a hospital. Now, the proceedings under 13.2 and 13.4 have all been initiated, and the notices say that this is a company assets, secured company assets. The property is of an individual given in terms of a
Go to
guarantor.
DRT and convince them that the property is not liable to be proceeded against.
The difficulty that I'm faced, Your Lordship, is the fact that I have neither been served any notice. I'm neither a director nor a guarantor.
Go suo moto,
So from my
file an
walking-
application for being heard. File an application, file the documents. What prevents you from doing so? Instead of rushing to this court, you should have gone to the DRT.
No, the problem is, Your Lordship, because I'm not a party to any of the proceedings.
So
that has
all right,
happened
then
for
why
the
should
secured
we hear
assets.
you then? Then why should we hear you?
No, because the fact is remains.
Why
that the-
should we
the
indulge in this
authorities are
fact
not
finding?
going ahead.
Why should we indulge in this fact finding in inquiry, sir? Tell us. Your forum is the DRT. Go there, file an application that this is the factual position. You can't proceed against this property.
The authorities are now going to go ahead and.
That's bound to be there. Supreme Court, read.
No,
South India Bank.
I bow down to Your Lordship, but the only problem I face is because I'm not a party to any of the proceedings.
Doesn't
that has
matter.
happened.
You at least could have made an attempt. If the DRT had not accepted your
Because-
application, you could have come.
I only came to know much later because I have not been a part of any of the proceedings. The guarantees
Still
have
heavens have not
been
fallen, sir. Go to the DRT.
confirmed.
Do
Would
you
Your
need-
Lordships at least give me that liberty with the fact that they can protect me for till the time I go to.
No
Because,
question
Your
of
Lordship, they are
protection,
going
sir.
ahead.
We are
I've
not,
already said.
we are not entertaining your petition. Where is the question of protection being provided? The Honorable Supreme Court says, keep your hands off.
But the problem I'm faced with the fact that I am
Yes,
not a part of
problem.
any of the legal.
Is a self-created one because you chose the wrong forum. The
Sometimes
highest liberty we can grant you is approach the DRT with
I'll be
suitable
extremely
application.
grateful for that. With a,
And counsel
Wait.
for the petitioner submits that his client would be better advised to approach the DRT with a suitable application so as to convince that the property of the petitioner is being wrongly proceeded against in the proceedings under the Surface Act, which have been initiated by the respondent number,
Response number 7,
respondent number 7.
grateful.
The petitioner is given liberty to file a suitable application,
I'm sorry, Your Lordship, response number 6. I'm extremely sorry.
Response number
Not 7.
6.
I'm extremely sorry.
suitable application in the DRT. It is expected that such application shall be considered as per law.
I'm extremely
above
grateful for Your
observation-
Lordship's consideration.
The instant writ petition is closed.
I'm extremely grateful.
Item 54 to 56.
My lords, I appear in item 54, my lords.
Yes.
Yes. My lords, in this matter, we have challenged a notification for appointment of persons to the National Council of Transgender Persons under the Transgender Persons Protection of Rights Act. My lords, this matter was heard for some time. And then on the last date, my lords were pleased to pass an order directing us to implead the National Council as well. This is my lords order dated 27/6.
Has that been done?
My lords,
That has been done.
Impleadment has been filed.
Yes.
But then notice, Notice has to be
they
issued in
should
the
come on
order.
record. Yes, they should, they have to be, yes.
Is there any impleadment application? When did you file it? What is the date of the application? Can we know?
If the advocate on record there can just assist court, my lords.
There is no impleadment on record. No impleadment application. No.
We'll take steps, my lords. Let the,
We have
we'll
filed
take steps.
Find out.
because the case status shows we have filed.
This court is informed that an application to implead the National Council of Transgenders as a party respondent has been moved on. Can you tell us the date? No idea. All right. Has been moved. However, such application is not tagged with the record. The prayer for impleadment of the said respondent is accepted. Amended cost title will be furnished within 3 days. Notice of the PIL petition be issued to the newly impleaded respondent. There is no application as yet. The registry noting doesn't say. Maybe it may be in defect. First, get it checked. Without checking, how can we pass this order? We'll pass it or we'll find out whether the application is there or not. If the
Grateful,
application is there, then we will pass this order. Rule is
grateful.
mandatory. You will serve the notices.
Yes, we have served the Dusty services. To
Whom?
all the
National
members.
Council of Transgenders.
Oh, National Council, we
You'll
have
have
not
to
done
serve
that.
the notices. Let process be, if the application is found to be in order, comma, let process be issued to the respondent sought to be implemented, that is National Council of Transgender. Rule is, Dusty service is permitted. Steps be taken in 3 days. Rule is made returnable on.
Your lordship, on the 2nd of this month, we have filed the affidavit. The
The-
case status shows.
Not the affidavit. Affidavit, it is mentioned. Application for impleadment.
No, that is what application for implement has been filed on 2nd of this month. But the case status shows as an affidavit.
That's
I don't know what
all
affidavit.
right, okay. Paper book oblique affidavit. It's 163. Let's see. And now what you have done is you have directly impleaded in the cost title. There is no prayer for impleadment. Read the application. Do you have any? What is the prayer in your affidavit? Let us see. The petitioner has, rather than filing an application for impleadment in terms of the order dated 27/6/23, the petitioner seems to have filed an affidavit wherein, the National Council for Transgenders has been impleaded as a respondent number 2.
Your lord.
Would not have been, should have been the last respondent. Anyhow, we'll ignore that now. The affidavit is treated to be a prayer for impleadment, and hence, let notice upon steps for service being taken, let notice be issued to the response numbers 2 and 3.
Only
2,
two.
3, 4, 5, 6. You also impleaded the members.
No, your
They were
lordship.
already impleaded.
They were already impleaded and we have taken the Dusty
They have-
steps. Only Dusty has to be taken on respondent number 2.
The National Council for Transgender is impleaded as a party respondent. Steps for service be taken within 3 days, whereupon custody process be issued. The Land Council for the petitioner to file an amended cost title in the main PIL petition. The amended cause title has to be filed in the PIL petition.
Yes,
Will
yes.
come up
Lordship, we
at
will.
the first page. Rule is made returnable on in 4 weeks. What about the other two? Any effective orders to be passed in the other two?
Your Lordship, we will take PIL number 2. Before that, I will just pray your Lordship, I have sent a soft copy so that your Lordship can pursue the same.
Hard copy, that is not a soft copy. A printout, no? What is it?
Your Lordship, the PIL is regarding the Constitution of Transgender Welfare Board. We shall take out the various exercise relating to the various welfare measures for the development and upliftment of the transgender community. Whereas the state is bound as per the rule of Transgender Act 2019.
What are these photos depicting?
I will clear it, your
Yes.
Lordship. So now the state is bound to establish a state level protection cell to look out the various offenses made towards the transgender person.
Yes, yes.
Even though in some cases, if transgenders are found to be an accused,
That's a different
But
thing.
that's different thing, but the police doesn't have even right to cut them, stripe off their clothes, and what is this going on? The state is silent.
You have to place these things on record, then we can put them.
Yes, yes, we will place it in
Place
record.
on record.
This has just came in the morning, your Lordship.
All right, you place them on record. You do it today. We'll take it up after 3 days.
Yes, yes. Well, this is very serious because in each and every police station it is going on.
In the packet, submits that she has come across material indicating that the transgenders who are apprehended with accusation of offense are being stripped in the police stations. The relevant material be placed on record. As per the petitioner's counsel, this is totally undignified and infringes the right of the transgenders, infringes upon the fundamental rights of the transgender persons. The relevant material be placed on record, re-notify on 16th August?
Yes, yes.
16th August. What about PL 6?
PIL 6 is relating to the advertisement. I don't know, they were about to give, place the instructions from the authorities.
What kind of advertisement, Mr. Nath?
Lordship, when not exactly the advertisement, what are the guidelines they will follow if the advertisement comes? I have received the instructions, Lord.
Then you place them on record, then just passing across the things
I'll place.
doesn't help anyone.
I'll place.
It's not praised for and is granted further opportunity to place the relevant material on record. List on 16.8. Then that PIL 52 will be detached.
The PIL 52 can also be listed on
But
16.
then we have given notice, you'll serve effect service by 16th.
By today only, I will serve.
All
the
right,
notice.
then listed on 16th. Rule is made returnable on 16th. List on 16th. Okay.
Item number 57.
Obliged.
Can this be taken on 18th?
18th.
18th. Lordship.
18th is holiday, Mr. Nath.
After 16th,
Then it comes
on
to 21st.
21st, Lordship.
Tell the
Lordship.
council, 21st.
I'm obliged. I'll
Inform.
Right,
Wait,
please,
Your
Lordship.
Lordship.
Yes.
Lordship, I have filed an affidavit bringing on record the order passed by the government of Meghalaya banning the use of imported fish.
Mhm.
And on the last date, my lord, the state respondents had prayed for time.
My lord, in this case, my lord, affidavit is ready. It is going to be filed today. my lord.
Today. All right, let it come on record and you let your affidavit also become taken on record.
It has already come, my lord, I believe, because it was filed on
1st
1st
August.
of July, 1st August, my lord.
Oh, yes, your affidavit is there on record. So would you like to respond? Let us see what the contents of their affidavit are.
My lord, because my lord, the institutions were directed to carry out the inspection way back in April.
Let us see
August.
what they have to say, madam.
Lord, and
The
the
affidavit on
Fisheries
behalf-
Association also had prayed for time. The Andhra Pradesh Fisheries Association had also prayed for time to file.
Arunachal or Andhra Pradesh?
But we are appearing for Andhra Pradesh Fish Farmers Association.
Yes,
We have filed our affidavit yesterday.
you have filed.
I have not received a
Who
copy.
will give copy?
All right. Affidavit on behalf of the state of Assam is proposed to be filed today as per the standing council, Mr. So and so. Affidavit on behalf of the, you've given a copy of your affidavit to them.
Yes, my lord.
We are interim, our names are not shown in the council list.
Affidavit on behalf of the Andhra Pradesh Fisheries,
Fish Farmers Association.
Fish Farmers Association has been filed, has reportedly been filed yesterday. The same is also taken on record. Re-notify on 22nd.
May I please, Your Lordship, in this case, I am appearing for respondent number 2. From day one, I am appearing in this case. And on my report, Lordship, the whole proceeding started. But nobody is serving copy on me, I do not know anything.
My lord, I am not aware.
I on day one, I appear, Lordship, my name is shown in the court.
You could have made a request, sir. We would have directed. Copy of the pleadings be provided to Learned Chain Council representing the respondent number 4.
Obliged.
Obliged.
Passover matter 52.
May it please the Lordship. In this case, basically, one clause of the 2015 policy of the state government regarding compassionate
There was a bunch of writ petitions which was allowed.
Yes,
was
Lord.
disposed of.
We have filed one. If it helps us, then we'll file the consequence for. The
So-
basic thing is that, Lordship, in 2017, new policy has come into place.
So we'll issue notice then,
Yes, Lordship.
issue notice to the respondent, steps which for service be taken within 3 days. Thus the service is permitted, rule is
If I
permitted.
may pray for staying of the order, Lordship, because there's a direction that we have to hold meetings immediately.
We understand, but the other matters you have not filed an appeal. If we stay this judgment, there is a stay in respect of the other parties. You should have filed appeals in all.
In respect of this, Lordship may pass that order. In the other case, we will
All
file
right,
in 3 days. time.
let us read the judgment. What is the ratio behind the judgment? Can you tell us, Ms. Saikya, in the meantime? So far as we can recollect, there are some contradictory judgments from the other benches. Can you have a look at that?
So far as a compassionate appointment.
Yes,
In fact,
same
this-
issue.
This all has become redundant now because the 2017 policy has come into place.
Was this argued? Was this argued 2017
It was
policy?
placed, it was said.
Let's see. Was this argued? Was this pleaded before the learned single judge? Let's see.
Basically, it will be all academic discussion now, Lord.
We
Yes,
understand, but
Lordship.
at least that argument had to be advanced before the learned single judge, Mr. Saikya. Or show us from your pleadings in the affidavit.
Yes, Lordship, I'll. My yes.
All the applications were filed up to
Or
2017.
else Lordship may take up this matter 1 week later. In the meantime, we will file appeal in all cases. On
Do
that case,
Because
Yes.
you just let us know one more thing. Whether all these applications seeking compassionate appointment were filed after 2017.
it
Or
was
before
some are filed little bit earlier also.
Those who are filed, which
But
are,
all the persons who died, they were before 2017.
that is all right. But if the applications are presented after
Yes.
2017, that makes a difference.
There are some cases which are recent one.
So
also.
you just,
In 20
you just
yes, I know
categorize
that.
all those.
In 2021 also petitions were filed.
List, simply list on, when do you want them?
Next Wednesday, Lordship,
Wednesday.
or Friday next, Lordship, may I just
Friday next is a holiday 18th,
18th. Then
18th
let
is
it be on 17th, Lordship.
17th.
17th.
That's great.
We'll file appeal in all cases, Lordship.
And in the meantime, you just have a look at some judgments of other single benches on this.
2007 Uchut Ranjan Das case, Lordship, that is direct contradiction here. That annex, we have annexed that judgment also
Yeah.
here. Highly obliged, Lordship.
The notice need not be issued in this. on
At
the
this
present-
stage, no. On simple adjournment, Lordship, all the cases maybe we will file.
Very good.
Service complete.
Highly obliged.
17th.
Only one issue, here there was a delay, we had that delay has been condoned.
Delay, it's not been listed or delay.
Delay is condoned, Lordship.
No, it's already registered. Yeah.
That is why it has been registered. In other cases, there will be delay now.
28 days.
28 days delay was there.
It was condoned.
It was condoned and therefore the case was registered.
Yes, naturally. That has been condoned on 2nd August.
So we'll file the delay condonation along with the appeals. Lord.
Do that.
Highly obliged.
Supplementary list, item 91.
They told that they filed some in this one of it, 90, which was mentioned, 91 only. Yeah, they filed some affidavit, we have told.
Private respondent. Private respondent.
Yes.
Lordship.
Someone made a mention that they filed some affidavit.
Maybe.
Yes.
Private respondent, BD court. BD court, sir. Lordship, may kindly take up the matter after 10 minutes on my records and the officers there on the web. They are after 10-15 minutes. How long? Private respondent.
Item 92.
The same thing, same. Then you can come to 94. 93 is a batchman. Yes.
Item 94.
May please, your lordship. Milord, this is a matter pertaining transfer of the petition, appellant, Milord. Milord, what happened in this matter for less than 5 months?
Service. What is happening in your state? Tell us.
This gentleman was retiring, so his pension papers, etc. And he was in a remote corner when in Longding.
So for that purpose, you have brought him to. But then the transfer, the shifting of the documents, that would create more hurdles rather at this stage. That is why one of the reasons for bringing in this instruction that in the eve of the career, the employee should not be transferred is that the transfer papers, then they get delayed. Because the entire record, service record, this, that, everything has to be transferred to the place where the new posting is given. That is the reason. And tell us if this is the precise reason for the transfer, but he is happy. Even if it is delayed, he's all right. He doesn't mind.
My lord,
Or what we'll do it, Mr. Goswami,
call for the records, man.
we'll admit, we'll stay and list it after 4 months.
So I will call for the records, man.
But what about this man? He'll have to join the post. 4 months to go, sir. What are you doing? Admit. Issue notice, Mr. Goswami, Additional Advocate General, Mr. Goswami puts in appearance on behalf of all respondents numbers. What is number 3 is vice?
Vice.
Process for service be effected. The step for service on respondent number 3 be taken within 3 days, whereupon process be issued. Heard on the prayer for stay. The appellant herein is posted as DFO, airing Wildlife Sanctuary, Pasighat.
Diaring.
Hmm?
Diaring.
De-airing.
Yes.
De-airing is written here. He is to retire on 31st December 2023. On the verge of his retirement, the petitioner has been transferred to
Bandareva, to the office of the
WSC
chief.
Bandareva.
Yes.
CCF WSC Bandareva.
Yes, ma'am.
In view of the facts and circumstances, Learned Counsel Mr. Das submits that the transfer of the appellant in the eve of his career is absolutely unwarranted and contrary to the guidelines. In view of the peculiar facts of the case, we hereby direct that effect and operation of the impugned transfer order dated 13/7/2023 shall remain in state.
Deeply obliged.
Item number 95 and 96.
The rule is made returnable in 10 weeks. By that time,
Lordship, for timing of this matter, your lordship, I mean, appearing in item number.
It's that APDCL matter, my lord, where pension was given, my lord had then protected us to a certain extent that will be applicable to the petitioner, the respondent in the second case. Now, my lord, there is a spate of petitions being filed. And now we are in a country. That's why my lord had on the last occasion fixed it today, my lord. Let them come, my lord. My lord will have it after some.
What do you want?
After some time.
After some time. Lordship.
All
Time.
right. 90, take it. Call it. Yes.
95, 96, same.
95 and 96. 99, let's take them. Mr. Roy is here.
Item number 90.
My lord, I'll check that, my lord. There are some respective quotas, my lord. OBC, my lord. Petitioner number 1, my lord.
Yeah.
Petition number 1 is OBC, my lord. And petitioner number 2 is the general candidate. 3 is the STP planes. And 4 is OBC, 5 is OBC, 6 is OBC, 7 is OBC, 8 is.
Where is Ms. Mahanta? Let them pass over for second now. Pass over. Let the other side come. Hearing matters.
Daily list, item number 1.
Adjournment slip. And adjournment slip has been circulated. On behalf of the bench. List of 4 weeks as written. This is a writ appeal of 2023 plus comma. Consideration of the writ petition. Writ appeal is deferred by 4 weeks.
Lordship.
As prayed by counsel for the appellant.
My appearance may kindly be
Appearance, yes, of course. Mr. Saikia's appearance will be noted in the.
for respondent number 41,
Yes.
Dr. Khanna, Subhas Khanna.
Item number 2.
Counsel is talking on the mobile, standing in the court. Really disgraceful.
May I please, your lordship? Lordship, the matter may be taken after some time, lordship.
The entire list may be taken up after some time. All. Pass.
Item number 3 to 48.
Lordship, I am
Yes,
for the
please.
state, Lordship. I have been agitating this matter.
Yes.
I'm
please.
available online. Of course, it came up suddenly, so I apologize for not being there physically.
So
The other side, if it wishes to start, they can, Lordship.
we
For
are
my
taking-
arguments, I'll seek a date so I can then come and satisfy Lordship in person.
You
That's
can
it.
address us by VC. We don't have
As
any.
Lordship says, as Lordship says,
Connection is very good, sir. The connection is very good, so we don't mind.
I'm obliged.
It's absolutely up to you. If you are not comfortable addressing by VC, that's your choice.
Not at all, Lordship. I do
All right,
it.
who's for
I'm
the
here to assist.
appellants?
May I give a background, Lordship, till the appellants come?
Mr. Roy, there's a difficulty. My.
I'm
sister-
Nalin Kohli, Lordship. My junior has logged in, Lordship.
Mr. Kohli, we have a difficulty, practical difficulty. Honorable
Lordship.
Sound will not be able to.
Oh, I understand. I
100% only. Very well.
So may I, if Lordship, if it pleases Lordship, it will of course come up sometime again. We'll join again. But if Lordship is indicating a fixed date, I may be able to come.
No, that's not the situation. We are taking up the matters.
Okay, Lordship.
Therefore, the appellants. Whosoever, item number 2, Ms. Saikia, Mr. Datta, Mr. Ken Chaudhary, Mr. Borbora.
May I give an overview if Lordship pleases?
Yes,
without it?
Please go ahead.
So
Yes.
Lordship, this Lordship is actually a matter relating to the APSC Lordship, which is the Assam part. Now, what had happened, Lordship, there were exams in 2013-14, and then there was the 2015-16 batch that came. During that, I'm giving a very short overview. During that Lordship, what happened? There was a complainant, one lady, Anshumitra Gogoi. She was approached by someone who was a candidate who said, if you pay this amount of bribe, you will be able to make it into the APSC. The system can be managed. She became a complainant and an FIR got filed in Dibrugarh, Lordship.
Yes.
That FIR led to a very detailed investigation,
Hmm.
and in which there was a huge number of arrests, Lordship. And
Hmm.
these people were all arrested. And then what is interesting in this, Lordship, is that the answer sheets were sent for forensic analysis. Now, what was the modus operandi, Lordship, by the then chairperson or the chairman of the APSC through some of his employees in APSC and a set of touts? What the modus operandi was, those who paid amounts varying right up to about 35 lakhs each, from about 10 lakhs to 35 lakhs, Lordship, they got a second chance to write the exam. Now, what had happened is the chairperson or the chairman of the APSC then, his brother had a printing press, Lordship.
Okay.
The brother printed answer sheets without being authorized to do so. After the exam, the candidates had a chance to come and rewrite the examination, and the invigilator's signatures were put there. So the papers came out from the strong room, answer sheets were replaced, it went back. This was all part of the forensic audit, etc. The answer sheet, his signature came, invigilator did not mark, things like that. It was detailed, and this led to the arrest and subsequently discharge of these petitioners. They came up, Lordship, in a writ petition.
Discharge meaning they had been appointed, they had been offered appointment orders.
Yes, Lordship. They were all probationers in government at that time.
All right. Okay.
So, Lordship, so therefore, this became a case of a colossal fraud or a tainted entry into the service.
We are told that the trial is at the fag end.
Yes,
Probably 313 statement has been recorded.
Yes, Lordship. I'm so obliged. Lordship is updated. Deeply obliged. So, Lordship, what had happened is, I can give the numbers also, but I'm giving an overview. This, Lordship, led to their discharge. They challenged the discharge. And the learned single judge, Lordship, of this honorable court went detailed into everything, looked at every case file, and looked at the law laid down by the Supreme Court, and then passed the impugned judgment. Now, Lordship, this corruption in public appointments has not come up for the first time. There is a history to it. It has happened Punjab, Bihar, other states, Lordship. And what the Honorable Supreme Court, through a catena of judgments, Lordship, has essentially held as follows. If it is possible to segregate the tainted beneficiaries from the others, I'm sorry, Lordship was saying
that
something.
is chaff from the chaff. From
Yes,
the
Lordship. Absolutely. I think Lordship then is away, the grain from the shaft. Absolutely, Lordship. So if one is able to segregate the tainted from the untainted, then no action must be taken against them and the examination must not be scrapped. Alternatively, if it is not possible to segregate the tainted or identify the tainted, then the entire examination must be scrapped.
Entire process goes.
Yes, Lordship, I'm obliged. Now, this matter agitated the state heavily because, Lordship, this is a public office, involves public trust. They were beneficiaries of a colossal scam. And Lordship, the question came, can they occupy the public offices? The state stand was, the state is obligated to take action against them. And the Honorable Court, Guwahati High Court single bench, Lordship, basically looking at all of this, arrived at the conclusion, their entry is not bona fide into the service. Therefore, the rules of service and therefore their argument of violation of audi alter partem is not going to be accepted because the rules of service would apply for a bona fide entry, not for an entry which is tainted, and the rules of service cannot apply prior to your taking birth in the service in that sense. And then, Lordship, the other thing concurrently, Lordship, this honorable court also entertained PILs. It was in the public space, Lordship. It is a very big discussed case. It was in PILs. Then a commission was formed by a respected High Court judge, Lordship. The chairperson was arrested. He finally got bail, Lordship, after 6 years, 7 years. 3 times at the Supreme Court, it was rejected. So it being a very, very tout. So this is their appeal, Lordship, against the single judge's judgment. And I will, of course, Lordship, have the opportunity to satisfy Lordship after they finish their argument. So I didn't want to give, I just thought
let us find out, sir, whether they are prepared today. Mr. Borgura,
as Lordship.
are you prepared to address the court today, or you want to wait for the outcome of the trial?
So far as my case is concerned,
Yes, please.
the cases are a bit
Yeah,
different.
we'll have to take up the cases together. It can't be in a segregated piecemeal manner.
No, because the learned single judge, my lord, erroneously roped in, my lord, certain facts and put me also there. But I will show that I will distinguish that I am not one of those.
Very well. So
there may be
you
things
mean to
like
say
that.
that we have to take individual cases of every candidate?
Maybe at, not my lord in a huge way, my lord. At certain joints, my lord,
Okay.
certain joints.
Very well.
And my lord, as my lord, learned friend from the earlier said, my lord, certain things I easier said than actually proved in a court of law. Mere detention, my lord, in respect, and these words, tainted and all these things.
So the
these are not-
trial is going on. There is that's a common knowledge that the trial is going on.
Trial is
The
going on.
matter is at the fact and that also we know.
Trial is going on. I am also on dock, my lord.
You are also facing trial.
I am also on dock. Trial is going on in the other court, my lord,
Yes.
especially.
So would it not be better that you wait for the outcome of that
I
trial?
leave it to your lord.
That's your choice, sir. We are ready to hear right
No,
now.
because there are other petitioners also.
I would only respectfully, Lordship, say that if all are taken up together, it would be good
They
because
have
my
to be
argument
because-
will be single.
They have already been tagged, sir. So they have to be taken up together.
Yes, I'm
Maybe the
obliged.
arguments would be individual, but the judgment would be the same. The common
Absolutely.
judgment.
My response would be also, Lordship, together.
Yes. The other council, please. There's a whole.
I think there are 13 cases. I cannot speak on behalf of others, my lord. So far as I am concerned, I am at the
Mr.
disposal.
Das,
I was just because it was, my lord, my item is item number 43, which my learned friend has said there are some case which trial is going on. That is in connection with Bhangar PS. But Dibrugarh PS case, I have been told, instructed by my junior, there's only 3 witnesses has been only examined.
only.
And it's on a Dibrugarh PS case where 488 witnesses, which I have.
So
been
that
told.
trial will take.
That trial will take. Bhangar PS case, of course, that's a different issue.
Okay,
But this related to Dibrugarh PS.
we understand.
That's why.
But
there are a lot
but
of-
the persons responsible are same. The chairperson responsible
No,
is the same.
chairperson is the same, chairperson.
Rakesh Kumar
Yes.
Paul.
No, there are what my
Yes.
learned friend I was hearing, my learned friend just narrating giving a real picture of the whole case. I will, my time will come. I'll definitely argue before your lordship how, my lord, it has been discharged. There are 3 stages which I will try to argue before your lordship, not now.
Not
No,
now.
my lord, there are other counsel also, they will start.
Please give us a concerted opinion whether you
So far
want
as
to
I am
argue today or
concerned, my
not.
lord, I know the trial is on, but I cannot say that it is a defendant.
No, I
Maybe
told your
from what
lordship,
Mr.
that's
Das
what
says,
I
it's a different case. There is one trial which is going on in Guwahati, in Kamrup
Not
itself.
taken, no.
That we know it is at the second.
There are 2 trials,
Must be, yes.
2 trials.
So.
I think both are in Guwahati, Lordship, subject. to
Both are in
correction by-
Guwahati. Both are in Guwahati.
Mr. Nath, can you tell us about the stage of this case
My friend is there in the trial.
for,
Lordship, I am additional special public prosecutor in those trial, Lordship.
okay,
In one trial, so far as this case is concerned, that PW 1, 2 and 3 has been examined, they have been discharged, Lordship. And now on 9th, next 9th, Lordship, there are 2 PW.
how many witnesses are cited in all?
365 witnesses have been.
So
cited.
so the trial will
And
take
Lordship,
years.
Another case, Lordship,
Uh,
which is a audio examination, all DW has been already examined. Lordship.
that we know, that we know.
Now, Lordship, the case has been stayed by this honorable court in a transfer petition case, Lordship.
It has been stayed.
State, no, only one petition has been stayed for which, Lordship, practically case has been stayed, Lordship. Transfer petition number 16, Lordship.
My lord, so far as Dibrugarh PS is concerned, my lord, Dibrugarh PS, which your lordship is now taking up, Dibrugarh PS case, out of 488.
That yes,
Yes,
365
so
out
your
of
lordship is
365, only
hearing
3
this,
witnesses have been examined.
This is your lordship is hearing this case, is connected all 60, I think 60 has been discharged out of 421. So 420, so they segregated.
365 witnesses are now remaining to be examined and
Now, my lord, what the government has done, they have segregated tainted and non-tainted. Now this non-tainted, my lord, equally that person who has appointed, they are also responsible, but they are continuing it. So how they have done it? They have placed certain materials before the court with seal cover that this is what they, basing on the charge sheet, my lord, all this they segregated and they found these are tainted, non-tainted. So we have to argue on that, my lord. I think Mr. Chaudhary, K. Chaudhary also reading in some of the case, DK Mishra is also leading some of these case, my lord.
Right.
So my turn was, I don't know, 43, I was
May I
just
respectfully
behind
come
the
in?
back, my lord.
Yes, please.
There were
Lordship,
some-
I think
there
if
were
I may,
some-
of course, whatever Lordship pleases, perhaps Lordship may be kind to put a date later this month and we should hear it, Lordship. We are ready.
We are all set, sir.
I know
It's
Lordship
just
is ready. That's
11
why
o'clock. It's
I'm only
just 11
gently
o'clock,
leaving
sir.
that for
We have
Lordship's
the
consideration.
whole day to go.
I know Lordship. It's a for Lordship.
Senior most. So we give always privilege to senior most, my lord. That's
Yes,
what,
Mr. Mishra.
yes, my lord. I'll leave it to your lordship.
Mr. Mishra, we have the entire day yet to spend.
Yes.
It's just 11 o'clock. What to do?
I'm ready, but I'm appearing in item number 2 and 27.
Mm.
5 and 27.
Mm.
5 and 27.
Okay, so just broadly let us know what is the argument.
But, my argument will be very short.
Mm.
The argument will be confined. In item number 27, I'm appearing for a lady called Sabira
Mm.
Imran.
Mm.
In her case, I will submit before your lordship that she has already completed her probation.
Mm.
And thereafter, she was, these FIR laws, she was arrested, and then they passed an order
Mm.
as if she was still on probation, extending her probation.
Mm.
Whereas I will
Whether
show-
whether there was any order of confirmation.
the confirmation is a different thing. My lord. Your lordship knows.
As long as the
It's a-
confirmation,
it's a-
order of
it-
confirmation is
yes.
not there,
My lord,
the
yes, my
the
lord, you are saying.
discharge from of a probationer from service may not be treated stigmatic.
My lord, no, stigma, it will depend. It will depend. Because, my lord, your lordship knows the veil has to be lifted, merely form of the order will not do. Then your lordship will consider from the facts of the case.
Mm.
I'm just saying what is the case.
Mhm.
So this will be the one aspect of the matter that she has already completed, and there is an order that she has completed her probation. There is an order.
Mm.
Now, confirmation, I will come when I check up, if I argue my
Mm.
points on this. So first will be this in respect of Mrs. Imran, that she has completed her
Mm.
probation period.
Mm.
And the second aspect of the argument, which will cover most of the petitioners before your lordship, is whether merely on the basis of police report,
Mm.
they can be dismissed from service, they can be terminated from service.
Mm.
And what the stand that the state has taken, and of course, the stand came to be taken after Mr. Kohli stepped in.
Mm.
Before these stands were not there were two affidavits.
Mm.
But the stand is that misconduct, pre-appointed misconduct, there is no question, even principles of natural
Natural
justice
justice would not apply.
And post, yes.
Mm.
So since this relates at the entry point,
Mm.
at a pre-appointment
So
stage.
there was no requirement of adhering to the
That's
principles
the
of
case. So these are the 2 points on which I will submit, because your lordship, the trial is
Then
on.
if everyone is agreeable, we can fix a particular day on which the other listings will be
My-
little less.
I'll leave it
On
here.
that, we can hear these matters.
Yes.
All right.
Some time ago, there are so many appeals.
Yes.
Some time ago.
We'll give you ample time, don't worry. That's not a difficulty. Time is, we have got a lot of time at our hands. So like, when do you want the matters to be listed? Please tell us a date with consensus.
Lordship in August or September, what would Lordship prefer?
September preferably,
September,
because
Lordship.
August we already fixed many matters.
13th, 14th Lordship, if it suits everybody, I'm making a request.
Yes, ma'am.
Ms. Mishra,
Man.
13th, as jointly prayed, list on 13th September at top of the list.
I'm so obliged, Lordship, ladies.
Item number 50.
What has happened to the appeal? Well, there was an appeal. What has happened to that? You are enjoying a stay. There was an appeal on behalf of the respondent. What has happened in that?
Subsequently, my lord, I have been appointed also, my lord.
Appointed on what basis? Your original appointment was subject to appeal.
Lordship.
What has happened in that appeal?
That is pending, madam. That's
Why
not,
that appeal is not being decided?
we don't know, my lord. That's our case, my lord. That day it will be decided.
Who represents the authorities?
Pardon, my lord?
Who represents the authorities?
My lord, the state, my lord.
Panchayat,
Revenue department.
revenue. Yes, madam.
Lordships already, governor has been appointed as per honorable court order.
Appointment is all right. What we are asking is that is appointment as pursuant to the stay granted by this court. There was an appeal
Lordship,
against his appointment. What has happened to that appeal?
Lordship, they have stated yesterday verbally that no appeal is pending, Lordship, but they are supposed to give
And-
instruction today itself. Lordship.
You please
Yes, 2 PM,
come
Lordship.
to the judgment of the single bench. Read, please. You have the judgment?
My lord, page 48, my lord, they have annexed the memo of appeal. It was not even not numbered, my lord. We have also
Whether it has
charged,
been presented, Mr. Chakraborty, whether
Lordship,
the
we have-
appeal was at all presented.
we have,
Of course, I am not the counsel. There will be contention before
All right, and the order of the learned single judge reflects that the writ petitioner within bracket private respondent herein had submitted an appeal before the respondent number 3, assailing the selection of the respondent number 6 within bracket the appellant herein for appointment as Gaon Pradhan. The fate of the appeal has not been brought on record till date. Learned Standing Counsel M.S. Bora to apprise the court regarding the fate of the appeal, if any, filed by the writ petitioner Ikramul Hussain before the Commissioner, Lower Assam Division, Guwahati. List after 4 weeks. Hmm.
Pass over matter, item 2.
May I speak, Your Lord?
Yes.
My lord, by this petition, I will challenge the validity of the judgment of order dated 6/3/2019,
Mm.
passed by the learned single judge. My lord, the single judge has not dismissed my petition, but certain directions have been issued by them. Those directions by the time have become illusory, my lord. Your lordship will come directly to page 56 of the order, my lord,
Para.
and relevant para is 6/9 at page 58, my lord.
Para 9.
First, my lord, let us come to para 6,
Hmm.
page 58, my lord.
Hmm.
May I read it, my lord?
Yes, please.
That the learned government advocate has submitted that pursuant to various orders passed by this court. From time to time, at present, the petition is now being paid a honorarium of rupees 7,000 per month. And he further submits that he has no information that the petitioner is still currently engaged in the government BDS, deep and
Your
dump.
prayer, Mr. Bhatti, in the writ petition was for regularization.
My prayer, my lord, for that is for regularization of my
So-
services.
Regularization of service.
Yeah.
Now you were working as a helper to the
Yes,
art instructor.
At the starting. And subsequently, I discharged the duties of the art teacher, my.
Well, tell us whether your initial induction, was there any post of helper to the art instructor? If there is no post, can there be a direction of regularization?
My lord, because if your lordship will come to the various orders passed by this honorable court and the affidavit submitted by the government, my lord,
Hmm.
they did not deny it, my lord. And for this particular purpose, first of all, my lord, I am taking to your lordship to page 43.
Para 6 says, he has no information if the petitioner is currently engaged in government BDS school Kahilipada. So what actually is the position? That was not even brought on record. Yeah, come to para 7.
Yes, ma'am.
That's what the answer to the query we have made.
Accordingly, it is submitted that there was no court for the helper to the art instructor and the petitioner are appointed subsequent from such and such. The case of revision could not be considered in terms of member number such and such. Which is regularization of service of workers who were engaged prior to such and such. That is the position, my lord, that this finding has been arrived. My lord, so far, the orders which have been referred in para 6, my lord, none of the orders was served upon, none of the orders have been produced by the respondent in this honorable court before the learned.
They are just policy decisions or office memorandums. They can be seen even now.
Yes, my lord, if that is in relation to the
Relation to?
there are various 29,598 that
Ms.
there are,
Nayak, madam, where are these office memorandums?
they have not annexed with their affidavit, madam, and they have taken this new plea. Accordingly, I replied to, and my reply in a
Yes, please.
Lordship, at page 58, Lordship, last line, so far as that OM of 7 to 1995, sorry, that 95 OM is concerned, Lordship. Ultimately, that OM has, that scheme has been set aside by the full bench of this honorable court, Lordship.
Okay.
So that is not there. Subsequently, in 2013, Lordship, we have issued another
Like, it's a
notification.
Slightly different situation. He is a person of specially able category.
Lordship,
So he has to be dealt with under the act.
Lordship.
Right. So now if you have been using his services for almost 20 years, he will have to be dealt with slightly differently.
Lordship, that.
What is the position now? Can you tell us? Whether he's still being?
no, I have retired.
You're retired.
Yes.
All right.
I retired during the pendency of this
There's
appeal,
no
my lord.
question of retiring.
0.5 to 2000.
There's no question of retiring. You were never employed. So there is no question of retirement. Your tenure came to an end. That can be a different phrase for that. So then what precisely would be the relief which can be granted to you now?
My lord, if I am regularized, in that case, I would be entitled to
The regularization, give us all right, give us the judgment after Uma Devi.
salary and pension, my lord.
Give us a judgment after Uma Devi. How was your engagement made? Was it on a regular basis? Was it on an encadred post?
Yes, ma'am, let it come after 1 week. In the meantime, I would inquire from the client.
Okay.
And after that, I will.
Mr. Bhatti, please for time. Please after 3 weeks. Yes, please.
First of all,
Ms.
90.
Nayak, you also get all those informations. What about how was his engagement made? Whether there was any post or not? Get all those details.
Lordship.
Yes, item number
First of all, matter 90.
90. Can you please recapitulate what matter was brief out?
My lord, will see, this is not that the experience was not considered.
Experience was not all right.
So 3 marks, that is my. Lordship,
So
may-
yes,
my additional.
yesterday the query was that cutoff.
Cut off, my lord.
So
But they are respective, but not the like 50, page number 51 additional affidavit. I've annexed the RTI reply. Lordship will see the STP plain. He is
page
the
number
petitioner, page number 51. He is STP plain. So
51.
similarly, in the page number 52, STP.
51 is not The 51 is the starting point of the writ petition pleading.
No, additional affidavit, my lord.
Yes.
It starts from page 45, petitioner number 1. That
Yes.
is score, my lord, 76.35. And the lowest in OBC category is 77.20. So he's also OBC,
You're
my lord.
referring to the RTI reply.
Reply, my lord.
Yes.
Then, my lord, petitioner number 3, page number 51. He scored mark 73.75, whereas in STP category, it's 70.5.59. Then lordship may see page number 52,
Yes.
appellant number 8. He scored 75.24. It is STP category, my lord. The lowest mark is 75.42. And writ petition.
Whether there is a pleading regarding the category in which they have.
Actually, when we filed the case, my lord, that time the result was declared, then we found that marks was not given experience marks. Then we challenged it, my lord. So there was no
Then there was no such specific challenge that we are of that particular category and therefore if 3 marks are added, we would go beyond the cutoff marks for the respective category. Where is that pleading?
That time, my lord, we didn't know that marks was.
The amendment could have been brought in an additional affidavit with the pleadings.
In fact, my lord, I will say, sir, in the Supreme Court, my lord, the APSC themselves, they went and they argued that 29 and 30 has to be followed. So there is a judgment. I placed this judgment before the single judge. That was not considered, my lord.
29 and 30
of the Assam Public Service Commission, my lord.
What is the provision? Let us see. Yesterday, the rules had been given.
I've given the copy, my lord.
Yes. Well, rules, yeah. Twenty-nine and 30.
30, my lord. The commission may determine the qualifying standard by giving weightage on academic merit, subject knowledge, additional relevant qualification, service experience relevant to the post, etc., for preparing the final order of select list. In the Viva's test, shall be allocated as follows: 50% academic professional qualification, service experience relevant to the post, preferential qualification, then 50% subject to the general hearing. Out of 20% shall be subject to knowledge, and remaining 30% of the general hearing. So this is a rule, my lord. And in fact, my APSC, they themselves went to implement in Supreme Court, my lord, about this 29 and 30.
In which recruitment?
In this. Same, my lord, department, my lord.
This was in relation to change of the category or criterion after the selection process has started. Therefore, that challenge was laid.
Yeah. But lordship is a finding at page para 16, my lord.
Yes, please.
In the present case, if the contention advised by the respondent is accepted and the next segment of the process of selection is carried under the 2019 procedure, it will give rise to an anomalous situation in as much as the screening of tests which was conducted without negative marking.
The commission didn't go on the aspect of experience issue which you have raised. It was a entirely different setup, that a new procedure was brought out in 2019 The commission said that that procedure can't be adopted.
Yes.
The old procedure will continue. Yes. But in the present case, that is not the scenario. Let us see how this aspect has been dealt with. The learned single judge himself says that the rules of 2010 would apply.
Yes.
Mm.
That is admitted fact that 2010 rule is applicable in this case, my lord. And this was the last round of selection, my lord. Thereafter, 2019 rules has come in.
All right, let us see where this argument has been dealt with. Whereas 14.
Para 14 is Harshi Tanmajat TJ Bhavanpal, London Senior Counsel representing APSC, however, disputes the argument propositions advanced on behalf of the petitioner. The senior counsel submits that there is no dispute with regard to the fact that in the APSC rules 2010, which is applicable, a proposition which is in consonance with the judgment of the Honorable Supreme Court in the case of Pankaj Kumar Sharma, that as per se would be not mean the experience would be an essential criterion for such recruitment. At the same time, the service rules 1980 cannot be wholly ignored in as much as Rule 6 lays down the process of direct recruitment to the post of Interior Agriculture Extension Officer, presently Agriculture Development Officer. The mention the term experience has to be tested from the context of its use in the advertisement as well as in few clauses of the form of
Para 18, you can come to para 18.
Dealing with the APSC rules 2010, Shri Mahanta submits that the recruitment of service experience is a discretion given to the commission and the same has to be relevant to the post. It is further clarified that rule clause 30 regarding the same. Replying to the submission that the recruitment process 213 marks were allotted for experience, Shri Mahanta has drawn the attention of this court to the affidavit and reply interrogatory application for vacating the interim order, wherein it has been categorically stated that the advertisement for recruitment in the year 2013 did not prescribe for any experience. However, it is a fact that marks were given without any authority of law, and the entire recruitment process was the subject matter of litigation, including a number of criminal cases involving legal rectification and said case, including some against the then chairman and still pending. Therefore, the said process 2013 would not act as a precedent. But this was never been pleaded, my lord.
Come to para 23, please. There was no specific indication in the form that experience marks would also be counted when the evaluation is made. There was no specific indication. So it was the discretion of the commission. They have done it uniformly. They have not given marks or experience. How can that,
My lord,
that
in
decision be
fact,
challenged?
in the
Come to rule 78. Rule 78, please.
Rule 78.
Yes.
Any doubt, right?
Had it been a case of discretionary application of that experience criterion, perhaps you would have been right, Mr. Roy. They have uniformly taken a decision not to give marks. That's their choice.
But my lord, with all respect, my lord, the last election was held in 2013.
That has been quashed because of wholesale irregularities. We were hearing matters arising out of that selection.
Not that
The
case,
same
no,
commission, same
same
body.
commission, but 2013, that time these allegations were not there, my lord.
Yes, that has been dealt with by the learned single judge. Come to para 19.
Because this is nothing to do with the experience, my lord.
That is what it is. Come to para 19. That is what the argument of learned counsel is.
Relying on the submission that in the recruitment process 2013, marks were allotted for experience, Shri Mahanta has drawn the attention of this court to the affidavit in reply to the interrogatory application for vacating the interim order, wherein it has been categorically stated that the advertisement for recruitment in the year 2013 did not prescribe for any experience. However, it is a fact that marks were given without any authority of law, and the entire recruitment process was the subject matter of litigation, including a number of criminal cases involved, illegal gratification, the said case, including some against the other chairman, still pending. Therefore,
Mr. Roy, otherwise also Rule 29 also says may. So the commission in its wisdom has chosen not to give marks for experience. Whether the court exercising power of judicial review can direct now give marks for experience. That will entirely create a chaotic situation. All the application forms would then have to be checked. You may not only be the candidates who had claimed marks on the basis of experience. Maybe the people who have been selected, they might be having experience. The seniority list would be changed. So they have adopted a criterion uniformly. How it can be said to be arbitrary? They don't want to give marks for experience. Well and good. It's their choice. Can the court force them? No, you have to give marks for experience. Is it a mandate of law? Can't be.
I leave it to your lordship.
Yes, all right. Thank you. Dismissed.
Crossover matter 91.
What is the affidavit which they filed today?
My lord, this is an affidavit filed by the private respondent, wherein he has brought on record a work order of 10/3/23, which he says I have not disclosed.
But just a moment.
I'm not going against you.
Additional affidavit which we have filed, we have only brought it on record. The documents which were produced before the learned single judge during the motion.
Fine.
It would not have been proper for us to just show the documents.
Right.
So we have brought in those documents.
Fine.
On
That has
record.
been taken care of in the learned single judge.
Single, I'm not against that. Therein, my lord, there is a work order admittedly issued to me on 10/3/23, not a work order, letter of acceptance. My case was that in the first case before my lord, the tender which was there, I had not disclosed this matter. Because the notice work order, but practically came to me only on 6/6/2023. In the next two cases, this is disclosed.
Okay.
And as to how, my lord, this is to be done, once my lord hears them, I'll place them.
So you first advance your arguments.
Lordship.
The appeal. You are the appellant.
My lord would find that the condition, my lord, my case was that the petition number 2 was a class 1 contractor. He had enough works with the PWD. He, along with 2 others, constituted the, my lord, petition number 1 company. And he had made an undertaking that all the works that I'm doing will now be carried out by the company. Now, one of the wings of the PWD, my lord, assigned the works under them to the company and freed the petition number 2. Now the company is looking after. But the works in the other wings, they have not issued a similar orders, and the works were continued with the petition number 2.
Individual name of the petitioner number 2.
Individual number, and the payments were made. So whatever works were given to us, we had disclosed.
Okay.
But the works which continued with the petition number 2,
Individual name.
we did not consider.
All right.
Now there was a complaint, and on the basis of the complaint, they wrote a letter dated 25 to all the wings, that if there is any pending works which has not been disclosed, kindly disclose.
Let us see the work, the letter.
My lord, that letters, my lord, they'll produce. On 26th,
Yes.
a letter comes from the chief engineer, border roads, that these are the works, it's not disclosed here, my lord. Next day. And the tender committee, basing on that, held me to be, I had held that I had misrepresented, and my lord, I was held to be non-responsive, and my lord, my bid security was forfeited.
Okay.
And this was copied in all other 2 cases. And now, my lord, for all times to come, this will be followed, my lord.
Okay.
Until date,
Your anxiety is for future tenders or for this work?
this, my lord, 266, my lord, if my tender was open, I would have been L1, my lord.
Okay. Your tender was, financial bid was not open.
Not open, my lord.
Okay. Very well. Let us see how this aspect has been dealt with by the learned single judge.
My lord would have it. My lord, the honorable single judge, my lord would come to page 227
Para
my
10.
contention, my lord.
Para 10.
Para 13, my lord. The learned so-and-so had submitted that. The work awarded to petition number 2 was not allowed to be transferred to the petition number 1 company by the chief engineer border roads. Hence, there was no requirement on the part of the petition number 1 company to disclose the work.
What about the bid capacity?
My lord,
There-
this
there are
bid
two
capacity,
grounds,
lordship,
grounds.
my lord would have that finding about the bid capacity in page 230, para 19, my lord. It was submitted that independent of whatever the bidders had disclosed in the bids, the bid evaluation committee had taken into consideration all the relevant factors and following the value was applied in respect of the formula of the bid capacity of the petition number 1 company. So and so it came to 0.44, which was less than the required total bid capacity. Accordingly submitted that the technical bid of the petitioner was evaluated as non-responsive. My lord would straight away come to page 214. That is the calculation which my friend had produced, my lord.
Page?
Page 214. This is the bid capacity calculation purportedly done by them. my lord. Here, my lord, in the top portion, my lord would find bid capacity. In the last column, that is, my lord, the appellant before your lordship, his bid capacity is 55.65. My lord has got it.
Yes, 55.6.
The requirement is 19.29. So that 19.2, right?
So even if it is 40 as mentioned in the single judge's order.
It's wrong, my lord. 0.44 cannot be that. The single judge, my lord, had made an error, my lord.
0.44.
He said 0.44. but Page 19.
0.44 or 44?
No, 0.44, my lord. 0.44. That's an error which has kept in mind. 0.44. Page 230. my lord.
Yes.
0.44. Whereas their own calculation shows it is 55.65.
Yes. So
It's a different
capacity-
issue, my lord, that the other works, that issue would be there, my lord.
So only that issue is that bid capacity as you
I have,
say.
with what I have given, I have.
All right.
And that was never the issue for which it was terminated, my lord. My bid was not held non-responsive
On this count.
on this
Okay.
count, my lord.
No, this made the submission that your bid capacity was only 0.44. That is reflected in para 19.
19, my lord.
Then let us come to that second aspect regarding pending works not being. disclosed.
Lordship. That, my lord, para 16, my lord, sorry. My lord, para 21, the final conclusion.
UDI and generated for another work.
That, my lord, with regard to this respond number 6 I had taken, my
Right.
lord may not go into that one.
It is-
Having regard to the natures of the disclosures, my lord, page 231, para 21. Is of the court of the primary opinion that prima facie it cannot be held that the decision of the tender evaluation committee in holding the technical bid of the petition number 1 to be non-responsive is bad or arbitrary or absurd. It appears that the authorities under the respond number 1 to 4, the bid evaluation committee had taken a conscious decision based on the understanding of the bid documents clause contained thereunder, which cannot be faulted. The senior counsel for this
So this is the interim relief which has been denied.
denied, my lord.
Okay. And what is the stage you awarded the work?
No, financial bid has been open and they are at the final stage.
Acha, all right. Okay, then let us see your reason of your decision, reason behind your decision making process.
Lordship wanted to see these are the communications. I have the original in file. No?
Let's see.
Lordship.
The bid capacity means not that argument was wrongly made.
No,
0.44, where does that figure come from?
The reason for rejection is misrepresentation.
So not the bid capacity.
Kindly see my lord, page 182. That is the reason. And the first copy, lordship will find this is the letter by which we have.
182.
182.
Clause 3.
182.
Copy from me.
Clause 3.
Para 3.
Based on representation received, yes, no, para 3, based on representation received regarding the concealment of existing commitments by the bidder.
Name Purvanchal so and so.
Purvanchal Builder Limited, necessary clarification was requested from the relevant head of the directorate.
So why explanation was not sought from the bidder himself? That is unilateral decision
No, Malad,
The explanation is not from the bidder.
Next page is the clarification reply given by them.
Let's see.
That is, I have given 2 pages, no?
Yes.
Lordship,
Next page.
next page.
Yes.
That
Where is
that-
the explanation?
No, we have asked them that whether there is any existing work.
Asked whom, sir? Your wings. When did you ask the bidder himself?
No, we have, to the authority, we have asked, Malad, that letter Lordship has seen,
Mr. Nath.
Malad. And Lordship may also see, kindly see, Malad. Ultimately, Malad, what are the materials before the authority while taking the decision? Lordship-
Yes,
Lordship
let
will
us see that, whether there was any work of Purvanchal Buildtech pending. Let us come specifically to that.
Malad,
Work of Purvanchal Buildtech. Where is the reply of your wings? 26/5/23, where is that letter?
Next page, Malad.
Next.
First page is the 25, 20,
Yes.
25 letter.
Uh,
Next page is the two
The
letters I have,
two
two
documents.
letters I have given, Malad.
Yes.
The record of memo. Original.
Now this letter proceeds on the premise.
The
The bidder named Matlebdin Ahmad, now known as Purvanchal.
Malad,
He is not known as Purvanchal. That is what he claims. That he is not known as Purvanchal for all works.
that is.
These are works in his individual capacity.
No, that is his claim in respect of the, while filing this writ petition. Kindly see, Malad, the documents which are available with the authority. Malad, the authority, kindly, Malad.
It's not the second page you have provided.
Yes.
It is in the individual name, Matlebdin Ahmad.
Our query, kindly see, Malad, our query.
Hmm.
First, the 85.5 law, the bidder named as Motlebuddin Ahmed, now known as MS
So
Purvan.
now how do you unilaterally hold that he is for all practical purposes known as that?
It is his representation before the authority.
Let us see.
Yes, Malad.
Yes.
Malad,
Page.
these are the paper. In fact, Malad, we have not filed the affidavit. We only got the instructions.
So you all right, what you do is you bring
I'm-
this,
I'm
Mr. Nath,
I'm
file a short affidavit here.
Lordship,
File
I
a
can-
short
I
affidavit
can- I
until
can-
that you restrain the process of proceeding further with the tender. 3 days time.
Lordship, Tuesday, Lordship, yes, Malad. On Friday, Lordship may take. Otherwise, Malad, all the roads, the works are very important, Malad, very.
Mr. Nath, we have seen in this court tenders
Correct.
being held up for 3
Correct.
years
No.
for no good reason.
No.
And the state also is not very keen to
Yes.
carry the matter forward.
Lordship,
So we are giving you just 3 days, not 3 years.
I'm just showing these two papers. What is his representation before the authority? Just for a moment.
File them on record
Malad,
so that he also gets chance.
we'll file.
This, you could have done it by giving him a simple letter, explain.
No, that instruction was sought. We have placed it before the London Single Jazz. Now,
Sir Nath,
notice has been issued.
There
We'll
is
file the
a
affidavit in the
concept called principles of natural justice.
It is Lordship. We'll file. Lordship may give us 2 days time, Malad, by.
Even as on date, you can do that.
Correct.
Seek his explanation and then you could have taken a decision. It would not have taken months for coming to this decision.
Malad, in affidavit, we'll file, Malad.
Now, file the
We'll
affidavit.
In fact,
It's not-
Malad, in some other works, he's doing both as per his convenience. We'll
So
bring
you
it on
bring
record.
these facts on record, so we
Yes,
don't,
Lordship.
the writ petition itself will be decided then.
Your lordship, will give an opportunity to place it from the affidavit and record the facts which your queries, your lordship has.
You also do that.
No, I have brought this affidavit. Your lordship will kindly look into the documents. From there, your lordship's query will be clear.
You bring them on record, sir.
I have brought it on record.
You filed the affidavit.
Yes,
Today.
Well, yes, because this is all part of the learned single judge. I did not want it to take your lordship from one document to another, just like my friend.
What is your affidavit?
Your lordship will
What is
first see page 242.
212.
242, the running page will be 242. Nowadays, we have the advantage of the running page, Malad.
Yes.
242, your lordship will see, this is the memorandum of association of the Purvanchal Buildtech Limited. Your lordship will see, which was submitted, this is part of the documents uploaded in the PWD website from where we have downloaded. Your lordship will see clause number 3. Further, all the credentials, technical, financial, experimental, managerial, and whatsoever from 1st of August 2022. Your lordship will take note of the date.
Clause 3.
Clause 3.
Clause 3 starts sell, lease, mortgage, so and so.
Top.
First paragraph.
Further, Further, all the credentials, technical, financial, experimental, managerial, and whatsoever.
May be counted,
What-
Mr. Kaur, we understand. May be counted, but he says that the PWD in certain wings did not do it, did not act on that, and his individual works continued.
No, my lord, there is even suppression in the case of PWD works. Your lordship will kindly look into the work order, which was
Let-
sorry, the
let
letter
him-
of
Mr.
acceptance passed
Kumar,
on
If he
263.
wants to respond, let him respond to your affidavit as well. Then
No,
we'll
my
file
lord, these
today.
were all part of the records in before the learned single judge. Against this affidavit, he has filed a response against these documents, and that affidavit is not made part of the writ appeal. How do I rely, my lord? I have given, they did not given a copy to the learned single judge. I gave my copy to the learned single judge. They have not annexed that affidavit with the memo. How do I refer, my lord? I am just a caveator. Your lordship will see that affidavit is not there on the record. I have been at least fair to them by giving them a copy. In the morning, the junior refused to accept the copy, saying that you are, and whereas that then the day when the matter was moved at 2 o'clock, I took the copy at 12. We are fair, my lord, to everyone, my lord.
My lord, let the respondents come up with that affidavit. My lord, everything.
What he's saying that there are some filings before the single
My lord,
bench which
I-
you have not
I-
placed on record.
My lord, I don't think so. With regard to these, I have made any filings, my lord.
No,
I'll just check up, my lord.
Not you.
No, they have not filed any affidavit.
But their affidavit, they have not enclosed
No,
with the
no,
memo.
my
over there.
affidavit.
Yes. So why that has not been enclosed?
It pages affidavit from last of that.
Copy has any.
And move copy to judge below.
All right, you
I'll also, my lord, that.
Right.
I'll check up.
try to place your things in order.
And even
Mr.
if your
Nath
lordship, my lord, even in the learned single
submits
judge.
that he has received the original record today and would be filing the relevant documents on record with an affidavit within next 3 days. Mr. Kanwar has also filed an affidavit on behalf of the private respondent today. The affidavit on behalf of the state authorities may be filed on or before. Today we are on 9th August. The response, if any, desired to be filed by the appellant may be placed by 11th August, by morning on 11th August, list on 11th.
My lord, 8th is tomorrow, my lord. You're filing.
8th is, yeah,
Tomorrow.
all right,
To
9th is
9th.
tomorrow. May
My
be
lord, we'll
filed
have
by
it on
10th,
Monday
may be filed by 10.
Ah.
The response, if any, on behalf of the appellants may be filed
by 11th. My lord.
by 11th.
My lord,
We
we'll have it
notify on
14th.
14th. Till then you instruct your officers not to finalize the procedure. And what about that appeal wherein your tender is L2?
L to the next one. My lord.
So we may close that.
My lord, only thing is that the same issue is there also.
All right, but in any event, your rate quoted is lesser.
L2, my
So
lord.
then what is
But
the point?
therein, I would like to have a liberty from my lord that I'll approach the honorable single judge because my bid security, my lord, now is
Single judges, the rate is pending.
Rate is
Otherwise
pending,
also, so we'll leave you at liberty
to
to
take
contest
up
regarding the bid security.
all them. My lord.
Uh,
Fine,
Ms.
268.
Nair
Next,
submits that in this matter,
268.
rate appeal number 302.
I'll just give it, my lord.
It's only in one or in two.
Only one, my lord. That is, my lord, writ appeal number 2030.
In writ appeal number so and so, Ms. Nair submits that the financial bids have been opened. And since the appellant's bid would
303, my lord.
stand lower as compared to the bid filed by the private respondent, he may be allowed to withdraw the instant appeal, leaving the appellant at liberty to agitate the issue of bid security before the learned single judge in the pending writ petition. In view of the submission noted above, the instant writ appeal is disposed of as withdrawn with the liberty plate for pending application. Number so and so is also disposed.
Lodge.
So there are one more appeal.
That they have not opened till now.
Okay. Lodge.
The next one they have not.
So 303 is
Close.
withdrawn, closed.
Lodge.
Okay.
Project 260.
We have 260.
All right.
No, 302 is not disposed of. Only 303
Three, my lord. 303. 296 and 302 will continue.
will remain.
Item number 95 and 96.
My lord will take up 96. That's the earlier petition.
My lord, item number 96 has been tagged with item number 35.
95,
95.
95, yes.
And in item number 96, my lord, after hearing both sides, my lord, Lordship was pleased to admit the appeal, refused to grant in the interim relief. However, Lordship was pleased to observe that if the benefit is to be taken, I must give an undertaking. I've given the undertaking, I think the benefit has been given to us.
All right.
My lord,
That
the
is how
last
the matter
occasion
stands.
when the matters came up, my lord had fixed it today, so that the matter can be heard and finally disposed of. My lord. I'm, my lord, placing that as to how this is not maintainable, my lord. The honorable single judge's order, I'll just place it, my lord. If my lord gives me a few minutes, if my lord can come to page 51, my lord.
In writ appeal number?
Writ appeal number, my lord, 107. Mukund Das.
7.
Very much senior APS, my lord.
Is page?
Page 51.
Can you give us the brief outline of the controversy?
My lord, what had happened here, the respondent number 1, who was an employee, he retired from his services on 31/3/2016. He was released on that day, and his pension and pensionary benefits that would be drawn by him, which will be from 1/4/2016, was paid to him. But the order was issued. Thereafter, my lord, what had happened in the year 2017, we had a revision of pay rules. This revision of pay rules came into effect from 1/4/2016.
Okay.
Now, in that revision of pay rules, whoever had retired on or before 31/3/2016, their cases were taken into account as to how their pension would be revised. And it was said there is a problem with the wording, my lord, which, my lord, led to this whole issue. Therein, my lord, the wording is that persons who were there in service on 31/3/2016 and who had joined after 1/4/2016 would be entitled to the, my lord, revised scale of pay. Now, this gentleman retired on 31/3/2016. Now, we are covered by we follow, my lord, the central government's CCS pension rules. For the, my lord, the employees of all the 3 boards, the CCS pension rules is followed. Now, the CCS pension rule defines how the pension and pensionary benefits have to be given.
Yes.
And my lord, rule 33 therein, if my lord can just have that, my lord, or my lord will have page 53 just to understand the controversy, my lord. Page 53. My lord, this is the revision of pay rules 2017. Rule 1(2), Roman 2, they shall deem to have come into force from 1/4/2016. My lord has got it. Then, my lord, the page 54, rule 4, my lord. It says, all employees who were in services as on 31/3/2016 or may have been appointed on or after 1/4/2016 shall draw pay in the revised pay structure applicable to the post grades which they have been holding or to which they have been appointed, as the case may be. Now, my lord, here, if my lord reads it minutely, it says that persons who were there on 31/3/2016 and who come over to 1/4/2016 will get the corresponding pay scale, revised pay scale. There is no revision as of 31/3/2016. My lord will have B also. Provided that an employee who was in service on 31/3/2016 may, at his or her option, continue to draw pay in the existing pay band and grade pay until the date on which she earns his her next or subsequent increment in the existing pay band, grade pay, or until she vacates her post or ceases to draw pay in the existing pay band grade. So, my lord, A and B together reading, my lord will show, it will be revealed that these is meant for revisions are meant for persons who are there as an employee on 1/4/2013. Now, the pension, my lord, pension is 55. Rule 32, my lord. Fitment benefit revision of pensioner, family pensioners. The pension, family pension of the existing pensioners, family pensioners, that is pre-1/4/2016 pensioners, family pensioners, shall be revised with effect from 1/4/2016 in the following procedure. The revised basic pension, family pension as on 1/4/2016 of the pensioners, family pensioners who were drawing pension, family pension as on so and so shall be fixed by multiplying the existing pension, family pension by a factor of 2.48, and the amounts so computed shall be rounded off to the next multiple of rupees 10. The basic pension for all purposes will be effective from 1/4/2016. Now, my lord, we'll have B. The revised basic pension in no case shall be lower than 50% of the sum of minimum of the pay in the pay band and the grade pay thereon corresponding to the pre-revised pay scales pay band from which the petitioner had retired. This, my lord, it says that if he has retired from a particular scale and that scale got revised, he will be given not less than 50% of that. But he will not be given that scale, my lord.
2.48, he will not get.
He will, my lord, not. My lord will see who will be applicable. This is important, my lord. This is applicable to those pensioners who retired on or before 31/3/2016 after completing 25/33 years of qualifying service, as the case may be. So, my lord, there is a specific provision provided for here. This was missed out by the Honorable Single Judge. Now, my lord, I'll take it further. Now, this is, my lord, the revision of payrolls. Revision of payrolls came into effect from 1/4/2016. They say that as I became a pensioner only on 1/4/2016 and 4A with that, my lord, reading 31/3 I am there, so I'll have to be given my revised. And along with that, all other benefits that come. If my lord can have the central services pension rules, CCS pension rules, and the same wordings, my lord, is there in the ROP of Assam government, and the AG has said we are determining it as of 31/3/2016. I'm just pointing out, I'll not go into that. If my lord can come to the CCA pension rules. CCA pension rules. It can take it.
Sure.
The list of the books there.
How is the learned single judge dealt with this aspect?
My lord, learned single judge, my lord, when with the reasoning, lordship would come. My lord, page 100. Page para 13. As per sub-rule 1 of rule 32, the pension and family pension of the existing pensioners, these words were found importance. Pre-1490 pensioner, family pensioner shall be revised with effect from so and so in terms of the procedure laid down by the subclause A and B. One of the issues that are arisen for consideration is whether the procedure laid down in subclause A and or subclause B can be made applicable to the case of the.
We admit this 272 and hear them together.
Because, my lord, the problem now we are facing, every other day there is a repetition file and an order is being passed.
There is one more aspect, my lord. This CCA rule aspect has been brought for the first time. In the earlier, my lord, neither before the learned.
My lord, that is the rule we follow, my lord. It's a law.
All right,
but in the affidavit, it should have been mentioned. So I'm taking the surprise. CCA rule.
Whether this argument was raised before.
No.
My lord, the argument which was there before the honorable.
You have your own set of rules.
Yeah.
Now you are going.
No. This is the rule which is being followed from the word initial.
Understand, but then your rules by itself specify the manner in which the pension will be calculated. You are now banking upon a different set of rules. Maybe you, with the understanding that these rules are all along applicable. But this was never the argument.
My lord, the difference here, what I'm trying to project before my lord is, this is the revision of pay rules.
So,
and the pension and pensionary benefits.
But they refer to pension calculation also.
Fine. That pension calculation will be under 32.
So, all right.
Because why, my lord, I'm saying so. If my lord reads the definition of emoluments in 33 of rule 33 of the CCS rules, it means the pay drawn on the day prior to the date of retirement of the pensioner. If that is now read into it, my lord, everything would be
This
clear.
is an argument which was never raised before single judge. Admit issue notice.
My lord, because why I'm saying so, page 54
of
my lord, the appeal.
54.
It means sum A, existing basic pay and dearance allowance, appropriate to the basic pay as on 31/3/2016. So this is what is getting revised on 1/4. But 1/4, the man should be there, my lord. If the man is not there, how will the revision occasion, my lord?
We'll consider that.
But the only thing, my lord, is one case, my lord, we have already, my lord, in terms of my lord's order, we have already given with an undertaking. Now there are other writ petitions also pending, wherein, my lord, the same order, but my lord had made that order limited to this case only. My lord, we'd have the interim order.
Yes, we now recollect that. Yes.
My lord had, but now that order is getting, my lord, without that,
In all, my lord, 4 writ petitions have been filed, out of which 3 has been, the order has been passed, and in 1, my lord, order has not been passed.
so my lord will hear the matter. There is no issue, but my lord, my lord will protect us to that extent. My lord will give a short date, my lord.
Admit issue notice, Mr. appears, Mr. Chaudhary appears for the respondent. Thus process need not be
In
issued.
item number 95, my learned friend appears, my lord. I'm in
Yes.
96.
So
My matter is already admitted.
Mr. Mukhtar appears for respondent number 1, thus process need not be issued. Who are the respondent numbers 2 and 3?
APDC. My
2
lord.
and 3 represented by Mr. List for hearing on
Short date.
21st September.
Okay. My lord, in this case, I will pray, my lord, that let there be a status quo as on date, my lord. At least in 95, because what is happening, my lord, we have to give this to all.
We have given benefit in 96.
No, but the 96, my lord will have that order. That is only specifically for him, my lord.
And following
22-3.
Similarly placed employees.
Yes.
How many employees are there?
There
In
will
all
be,
total,
maybe around 30, 40,
there are
my
5
lord.
litigations.
30, 40,
5
20,
litigations as yet.
20.
There
20
are
employees, my lord. Others are coming
But there are 5 litigations as on
Only
date.
5.
as on date. But my lord, if
So
5
you can
litigation-
always request the learned single judge that wait till 21st September.
Because my lord, my lord will have that order dated 22/3/23, my lord, for a minute, my lord. And the last paragraph.
Yes. So the same thing undertaking.
No, my lord.
Yes.
My lord will have, why the undertaking was there? My lord, after that, however, we make it clear that this order being passed by this court shall be limited to the case of the respondent herein only.
So that is for the purpose of single bench.
Yes.
That is for the purpose of guiding the single bench, not on us.
No, my lord, I'm not on that. My lord said that this, but the honorable single bench is losing sight of this first line, my lord.
That's a different thing.
Now we are in a quandary, my lord. If we have to dole out all this, otherwise also, my lord, we are in a very bad shape.
You have created this problem for
My lord, no,
yourself.
it's a question of interpretation. It's
So
not a
we'll
creation.
interpret it accordingly, that the future payments will be adjusted. Why you are worried? In future, the payments would be adjusted.
My lord, if my lord makes that observation in this
In
repetition,
case of
then-
if we make it.
then
clear
we'll have
that
the
in
other
case-
repetitions we can
In
follow.
case of the appeal being allowed, the payment being made, payment of pension on the basis of revision being made to the respondent would be adjusted in the future payments.
Payments. In both the cases.
Both
my
the
lord,
cases, same order.
Much obliged, your lordship.
Daily list for hearing item 59.
Yes, yes. What is the matter, madam?
Lordship, they were found, this accused person was found altercating with the deceased. Last seen, it is leading to discovery, your lordship.
Last seen and discovery
Leading to discovery and
Discovery
quarrel
of
had taken
what?
place. Of
discovery
the corpses, your lordship,
of
corpus,
corpse.
yes, corpse.
Yes. Discovery on the basis of his statement.
Yes, my lord.
Let's see. So far as what we have found, your investigating officers don't know how to record the disclosure statements. Who are the persons who saw the altercation?
Lordship, EW 1, 2, 3. Yes, my learned friend for the appellant, he is there.
Yes.
Lordship, if your lordship permits, may I see the records? I don't have the paperwork, but I'll go through the records and do.
Why you not collecting the
No,
paperwork from
lordship
the
is
office?
somewhere misplaced, your lordship. I've noted down from the
Original
paper.
record there, ma'am. Already, what you do is, Ms. Rakhi, give me the original record. Give the paper book to madam.
Lordship, I have noted down from the paper book available with Lordship.
Take the paper book.
Madam,
No, no, I will see for the record.
continue.
What he said.
Then. PW1.
My lord. He's a father-in-law and the informant.
Father-in-law of the
Of the
accused
deceased.
of the deceased. Gentlemen, why you are taking the seat? You have to assist the court as an amicus.
My lord.
All right, argue. What is the evidence?
My lord, this matter is actually pertaining to this appeal, jail appeal, and his trial court lordship, it is decide the matter on the basis of
You
the,
also don't have the paper book.
He's having.
yes, I have lordship,
All right.
on the basis of the disclosure statement made before the investigation of
Only,
lordship.
there
Only
was
the
no discovery in furtherance of the disclosure statement.
Only disclosure statement.
Yes, yeah. Sister, these are in Asmi's. Yeah, well, they will come report. Let us see the judgment first, okay?
Lordship.
Read from the judgment.
Yes. 65 lordship, 65. May I read it, lordship?
Come to the relevant part.
Relevant part, lordship.
Para 24.
PW1 is not a witness of last scene. 15 days
After 15 days.
before.
Yeah.
Lordship, but regarding the altercation.
15 days earlier. How it is the last scene?
It is, even it is not large scene also. It is separate, lordship.
Can we draw a conclusion that
No.
after 15 days, the altercation took place 15 days earlier and then the deceased was never seen alive? Is it the case of prosecution?
Lordship, 15 days in between. Lordship, it's a
So-
period is less than on Lordship may take into account.
Just soon before the incident, if there was an
Yes,
altercation,
Yes.
that would have been.
My lord.
Then that PW1 also says on hearsay, on the basis of Padumi Fukan.
PW2.
PW3 is the person who disbursed the moral.
Lordship, only PW3 is the
Three.
lordship,
Only PW3.
only PW3.
Yes, sir.
He has seen the altercation, nothing, and nobody has seen,
Only altercation. That's
only
all.
altercation. And thereafter, lordship, what happened? The PW3 separated them, and put both the accused in their home.
So
And
there is
this
no
is-
last scene then.
Yes,
They have separated.
yes, they separated. And thereafter, PW3 has gone. And this is the incident, lordship, and thereafter it is the disclosure
But
statement.
they, what public prosecutor was saying is that the corpse was recovered on the basis of the information of the accused.
Information of the, yes.
Who is the IO?
Lordship, here PW7 is also demonstrate, my lord, in his presence before very well. PW17.
Is PW17.
I will be PW17, no, PW17 is doctor, lordship.
Magistrate.
Mukul Sharma,
EDC Sipsara.
PW, yes, yes, Moon Gogoi.
Revenue Circle Officer.
Yes, lordship.
So the relevant evidence is of PW18. He is the only relevant witness.
PW8 is the investigation officer.
The convict is, there is only one person who has been convicted.
Two persons.
2%.
Two, Jiten Goda and
Forest Tasa.
Other one is acquitted, my lord, three.
Yes.
just.
He was arrested. and-
Paresh Kacha.
Yeah.
He is also convicted.
Forest Tasha. And one more important thing, Lordship, is the incident happened the place. That is also Lordship contradict. The IO stated near the accused resident, and while it is disclosure statement, disclosure statement, accused stated, no, it is some other place in the garden. Lordship.
Where is the disclosure statement? There is no disclosure statement at all. He didn't record. PWT. He didn't record even. Did your IO record the disclosure statement, please?
Lordship, he did not. Just his evidence is there.
Oral evidence. All right, where is the memo of discovery? Search and seizure list, exhibit 6.
My lord.
Original.
Iron rod recovered and wearing apparels.
Iron rod, whether it was sent for forensics.
No, your lordship.
Ah.
Even postmortem report, Lordship, doctor never uttered any single word regarding the iron rod. The accused was.
Exhibit 6 is the bicycle recovery,
Yes, my.
which is the recovery of the dead body. What is the seizure memo? Oh, this is exhibit 4.
A Ghani bag, my lord, sky blue stripe pose.
Exhibit 4.
Yes. It's a Ghani bag, sky blue stripe pose, so.
Madam, does it read, does the seizure list read that this dead body was being discovered in pursuance of the information given by the accused?
No, my lord.
So where does the magistrate come in, that executive magistrate? Who is the executive magistrate?
PW
PW?
17, my lord.
So what does the magistrate say? That the accused went there and he confessed, right?
Lordship.
So where is the confession? On 29/4. And when was the body recovered?
Mm. 29/4 itself, your lordship. Twenty-nine-four accused Forestasa appeared in the PS and surrendered. Said accused stated before me that he along with Jiten Goala had killed Mukul and thrown his body into river Dhanshiri. He further stated.
Confession before a police officer was
Forbidden
allowed to
by
be
law.
stated in court.
Yes, my lord, it is not there. Confession before the police officer is no confession.
How it was allowed to be recorded in the statement?
No, sure. Probably lordship exculpatory part will be admissible, my lord.
Was it ever recorded, madam? So what is not recorded? Oh.
IO made a prayer to SDO civil to recover the to deputy magistrate to recover the dead body.
Pathetic is the only word which comes to mind.
I understand your lordship.
This man is in custody for 10 years. The conviction is only on the basis of recovery of a rod. How is that incriminating?
But it was within the absolute knowledge of the accused. That is the.
What?
but they should
That
have
he has a
recorded.
rod in his house.
Lordship.
That he has an iron rod and a bicycle in his house.
No, and the place where the dead body was thrown, your lordship.
Was it shown out? Please read from which document are you saying? Ms. Saikia, we have, on Friday, we have awarded compensation to the accused on account of total false implication by a police officer. This is yet another case. 10 years custody without there being zero evidence. Of course, we are responsible also because he has been convicted for there being no evidence. Absolutely no evidence. The dead body was recovered floating in the river. 2 witnesses said that they saw the accused quarreling with the deceased 15 days ago. That's all. If the convictions for 302 were to be recorded on this evidence, not one citizen in the state of Assam is safe. It's a fit case wherein your police officers should be sent home and many more of the elements involved in this case. Anyhow, we'll dictate the judgment today itself. Is he on bail? Mr. Amicus Curie? Is he on bail?
No.
No.
There's a statement to record.
They are still in custody.
So how it is, the period is only 6 years, how it is shown. Incident is of 2013. They were on bail during trial.
During the trial, again, they arrested Lordship. They are in custody since Lordship 23/4/2013.
Ms. Saikia, this is probably the 6th or 7th appeal which I have come across wherein the investigating agency doesn't prove the arrest memo. The prosecution doesn't prove the arrest memo of the accused. So how the disclosures will be read in evidence, if at all? There is no disclosure in this case. The arrest memo is not proved. The formal FIR is not proved. Your state is desperately in need of a proper prosecution wing. Proper wing means proper, trained. The situation is of desperation.
We have realized that thing, Lordship, and the things are now, we have a lot of SOPs and training sessions are going on, and we are also going to have the prosecution directorate, Lordship.
Very good. All right. We'll pass that. Both.
Item number 61 to 64.
Probably in all probability we feel that in that period of insurgency, the entire focus must have shifted to
Law and order.
law and order.
Now it
So
has,
investigation, now you are
yes.
saying, Mr. Saikia, I have called for a file of NDPS seizure in 2021. If you ask me to comment on that, the things are still at the same place. Yes, all right. What is this matter?
This is regarding.
In this case, I would like to file a very short affidavit regarding the recent development, because their whole case is that the cooperative societies are not getting any money to run their activities. So the government has come up with a policy that I would like to bring in.
Saikia, Advocate General Mr. Saikia submit that he is desirous of filing a short affidavit in this case. He prays for and is granted 2 weeks time to do the needful.
Earlier occasion, central government was also directed.
Central government
Yes.
is missing in action. Affidavit on behalf of the Union of India has also not been filed. Leonard at Deputy SGI to do the needful by the next date. This up 4 weeks.
Deeply obliged.
Much of.
Item number 65.
May it please your Lordship. Lordship, I'm prepared to argue this matter, but one small technical difficulty. I am not the amicus. Mr. Joshadri Das, who has been appointed the amicus, but is seriously ill. Actually, he has lost his voice and maybe something very serious. So he had asked me to argue the case. So if your Lordship's permits
We
me,
can probably appoint you as the amicus curiae. What is the evidence?
my Lord,
Is the case based on
PW1 only
circumstantial evidence or direct evidence?
not
Direct to the-
circumstantial, but issue is the person is insane.
Mentally ill, 328.
Mentally
Only
treatment.
PW1 And in 313, he has stated.
313 has stated, my lord, if I may point out certain things.
Just hold
The Give me that note. No, it is not. I was doing
So he was last seen going away from the house of the.
Yes, by the daughter of the deceased.
By the daughter, PW1. So that is strong evidence.
But the same daughter, my lord, in her cross-examination, if your lordship comes to page 10 of the.
Mentally disordered person.
Mentally disordered person.
So the trial court never got
My lord,
that.
what has happened here? The incident is of 9/3/2012. I was apprehended that day by the local people, kept tied at the house of the deceased. I was arrested on 10/3/2012. Forwarded on 11/3/2012 before the magistrate. Now therein, it was written that I have to get the medical treatment that is supposed to be given to me. The medical slip says, go for psychiatric analysis because I was talking irrelevant things. That is on record. If your lordship, it is in the paper LCR records. That is of 11/3/2012. 12/3/2012, the IO files a petition before the magistrate with a prayer for recording my confessional statement. That is of 12/3/2012. I am brought before the magistrate. I am sent for reflection to jail custody. 15/3/2012, my confession is recorded. There is nothing on record to show that I have been treated.
So there is a confession.
There is a confession.
No, it was not exhibited.
It was later. The confession, my lord, it was not exhibited first,
Exhibited, my lord.
but this matter had come up for hearing in 2020 before the High Court. It was given under 391 that to make that
Mark
confession
the confession
exhibited
exhibit.
later on, and the magistrate was also examined who had recorded the
So there
confession.
has been evidence in 391 also.
Yes, yes. It's a small list of evidence of CW1 recorded on 5th of August 2020.
Madam, we'll have to direct for his medical examination to be conducted.
Yes.
And
Lordship, para
what-
16 under judgment, my lord. Learned trial court has dealt with section 84.
My lord, if I may, one more thing. There's an order of 18/6/2017. After the first PW1 was examined, there's an order of that time it was being taken up by the district deputy commissioner trial. He has specifically stated that when the accused was produced, it seems he's not normal. So it was a direction was given that please go for medical checkup. Now under 328, 329 CRPC, the proceedings has to stop. A separate inquiry whether I am fit to stand, give my defense has to be done. That itself is not done. My plea of relying on section 84 IPC will come later. But if the magistrate or the trial judge on his own records, if your lordship takes up the LCR, that order is very, very prominent. File A, my lord. LCR file A, I have flagged it. There's a pink flag. File A, page 6. There's a pink flag of 18/7/2016. The order says,
Seems to be a person of unsound mind.
yes, seen guilty. And my
Then there was a direction for medical examination.
yes,
What happened?
nothing. Record does not say anything. My lord, the second paragraph, seen the guilty plea petition of the accused so and so received through the prosecuting inspector. On query, accused could not say anything about the contents of the petition. But the entire inquiry that ought to have been done under 328, 329, it is not there. And it is not my plea of insanity. The court itself is saying that
Yes,
you are
of
not fit enough.
Find out from the jail authorities whether any inquiry was done.
Lordship.
Refusal of the
329 specifically says there has to be a specific, my lord.
a perusal of the record would reveal that right from the inception of the case, there has been indication that the accused was mentally unsound at the time of the incident. Even PW1, the daughter of the deceased, stated that the accused was mentally disturbed. The Deputy Commissioner Karbi Anglong Difu, who was at the relevant point of time conducting the proceedings of this case, directed on 18/7/2016 that made an observation that the accused seems to be a person of unsound mind and exercising powers under section 328, 329 CRPC, it was directed that the accused shall be examined at the civil hospital Difu by the expert medical officers to ascertain whether he is of unsound mind or not. And the trial of the case was stayed till receipt of the medical report. However, perusal of the record would indicate that the said order was never followed and the trial was commenced after being transferred to the court of the Sessions Judge Karbi Anglong. In this background, we are of opinion that a proper examination of the accused for finding out his mental state is essential for the just decision of the case. The accused thus shall be, we hereby direct, in which jail is lodged now?
Difu.
We therefore direct the superintendent, central jail, district jail, Difu, to forthwith. We therefore direct the IG prisons to ensure that the accused is transferred from the district jail Difu to the central jail Kamru within next 7 days. After being transferred to the central jail Kamru, the accused shall be presented at the Guwahati Medical College, where he shall be examined by a medical board comprising of 3 experts in psychiatry, expert doctors in psychiatry. The report of the medical board shall be presented for the court's perusal by the next date of listing. Re-notify.
If I may suggest, my lord, whatever the condition, if this medical board, it will be of today.
Obviously,
Under 328, the magistrate has to specifically see whether I'm fit to stand trial.
You're right.
That proceeding.
But as on date, what can be done? We'll ascertain what is his position now.
Yes,
Let us see at least that if it continues, that will give an indication even of that time. Re-notify on for hearing on 27th September. ऊपर लिखिएगा. Then counsel, what is your good name, please?
DK Bhattacharya.
Submits that the appointed amicus curiae, Mr. Jasadir Das, is not well and is not in a position to argue the appeal. In view of the facts noted above, we appoint Mr. Bhattacharya as an amicus curiae to assist the court in this and represent the accused in this appeal. Okay.
Item number 66.
Yes, please.
This is an appeal against the order of conviction and sentence passed by the Lani Session Judge Karimganj.
What is the evidence?
The
Direct evidence.
I'm reading, my lord. At the very outset, my lord, I read the FIR kindly. That is in page 4, my lord. With due respect, I the undersigned beg to submit around 3:30 AM of 10/12/2010 some miscreants and smugglers, very important smugglers, armed with sharp dao and daggers, trespassed out into the house of my younger brother, Majiruddin, aged 33 years, son of late Ahar Ali, situated at Noyagram. At first, these miscreants tied the hands of my 2 sisters-in-law, namely Khuzur Bibi and Shamina Begum. Thereafter, the miscreants started assaulting my brother, Maziruddin, on his head and other parts of his body with sharp daws and daggers. The accused number 1 and accused number 2 killed my brother by hacking his neck. My brother died on the spot as a result of severe injuries caused by the miscreant on his body. The accused number 1 and accused number 2 left my brother's house, taking along the documents of his landed properties. Then, my lord, accordingly, my lord, case was charged under 120B, 302, 342, and my lord, 458, my lord. And my lord, in this case, you also will find there are 7 witnesses have been examined by the prosecution, my lord. And I take your lordship of PW1, that is the first wife. This is 2 wives, they are living together, and first wife. And the whole scenario is that the house is just at the border of the Bangladesh. There is no fencing. And they just come in the evidence that frequent there is a trespass from the dacoits and miscreants from Bangladesh. They come
to PW2, what cross-examination has been conducted?
Let me read PW1 first, my lord.
PW1 has not identified you.
Yes.
Come to PW2.
PW2, I am reading, my lord.
What is the cross-examination?
I am reading, my lord.
Have you disputed
At about 3 years back, at one night about 2 o'clock, while I was sleeping in my own room in the husband's house, the alleged occurrence took place. Our homestead at the period is situated on the Tila land. As I could not give birth of the child, my husband got married about 3.5 years back with Shamima Begum. PW1 in his house, there are some rooms. My said sister-in-law, Shamima Begum, was sleeping in with my husband in another room, my lord. There are 2 rooms. In one room, second wife, and another first wife with husband. At that time, culprits, by breaking the bamboo fencing of the kitchen, entered into our house, seeing the focus of the torchlight. Torch was not seized here, my lord.
Not required.
I woke and went towards the room of the husband. Culprits dragged our mouth and with our shari, fastened both of me and my sister-in-law. They were armed with dao and dagger. After that, they killed our husband with assault of dao and dagger. They cut the neck when culprits fastening us. On the light of their torch, could identify the present accused Tajuddin and Bulukuti. They threatened us with their consequences in case we disclose the name. Before leaving the house of the culprit, again entered into the room of the husband, stating that they would finally kill my husband. After that, they left. After that, I managed to release from myself and release the sister-in-law in the same Tila. There are no other homestead. We both got down from the Tila land. Tila means well hillock, my lord. Went to the house of the Firoz Mullah. After that, neighboring people, Moina and the other villagers gathered at the place. I reported about the incident of many culprits, very important, many culprits, along with accused Tajuddin and Bulukuti, caused death of our husband. We became almost unconscious. Brother of our husband, namely Abdulaziz, came there and reported the matter to him. Police came out, but I cannot say anything at that time. I was semi-conscious. After when the police came again, I reported all the about incident. I gave statement before the magistrate. Now, my lord, you also will find here, he reported this Firozullah, who lost the affair. Firozullah. Then, my lord, then in cross, he stated that after the incident, I remained for about 5 months in my matrimonial house. After that, I came out from my parents' house. I am living as dependent on my brother and brother-in-law. About 7 months after the incident, PW1, the second wife of my husband, gave birth of a daughter. After that, she got remarried with the younger brother of my husband. House of the PW was brick wall and kitchen was with the bamboo fencing. The entire house was not fully completed. Then, my lord, I take your lordship this Kuzur Bibi, my lord, because she was again further crossed.
The cross-examination was kept reserved, not further crossed.
Again, the further
Process
cross.
continuing, yes.
Yes, continue. After all, the Abdul Roof and
Ali
yes,
and Abdul Rauf,
After Ali and Abdul Roof are our own cousin and are the same homestead. They are also my maternal uncle. They are uncles of the deceased Moziruddin. On the backside of our homestead, there is a tilla land of Paramanandar tea estate. I cannot say whether after that tilla land, there is a border of Bangladesh. I know the Bangladesh is on the western side of the village. I cannot say whether the distance of Bangladesh border from our homestead is about 1 kilometer. Adjacent to the high Tila, there is a house of Firoz Mullah. On the southern side of the homestead, there is a Tila land of Nazrul, which is intervening about 2 other Tila. Come on, please come start. Come. I'm reading this. On the southern side of the homestead, there is a Tila land, intervening 2 other Tila. Akkadas Alis and the Mokrom Ali are the younger brothers of my father-in-law. I do not know Kudus and Durmus. I can say whether they are the husband of the cousin of my husband. I cannot say whether the husband was an accused of Ibaduddin murder and subsequently got acquitted. Then my further cross I am reading. Since before the alleged incident, I knew the accused person. Sometimes they came to our house. My husband dealt with only betel nut. You know, this area is very famous for betel nut business, which is being transported from other parts. And agar business, it is very important material from Assam, agar.
Basically, base of perfume.
Yes, agar business. There is one house in our homestead length side, of which in north-south direction, on the northeastern side, there is a cook shed. The main house consists of 3 rooms. Entrance of the kitchen is inside the house. I and another wife of my husband on that night were sleeping in a separate room. In case of entrance to the kitchen, one is to cross the room to get the room of the stepwife of my husband. I do not know Babul and Malik as friends of my husband. And I cannot say whether any such friends reside in Bangladesh. I have no knowledge about the person who had business relation with my husband. I knew that one Akbar Ali, who was the uncle of my husband, sometime I visited his old homestead. My mother, Montu Bibi and Akbar Ali are own brother and sister. Before assaulting my husband, the accused person questioned me and said stepwife of my husband in a separate room with other clothes, our clothes. About 2 hours after the incident, we could manage to free ourselves. Their faces were not covered with clothes. After the incident, about 50-60 villagers came to our house. Moina Mia had business relation with my husband. It is not a fact that after the incident, I disclosed the villagers that some Bangladeshi nationals came to our house and killed my husband. It is not a fact that in the instance of Moina and Mia, I lost the false case against the accused person and I adduced false evidence. It is noticed that the witness of adducing evidence weeping. It is not a fact that I stated before the IO that the accused person fastened us, we were sleeping. I have stated before the IO that as the accused persons of our village, we could identify them both seeing from their face structure in the light of their torches and also could identify them hearing their voice. I stated before the IO that there had been land dispute between the accused person and my husband. Then, my lord, I take your lordship.
Any suggestion to the witness that she had a motive to falsely implicate your clients?
Nothing of that sort.
There is no suggestion.
Yes.
So why should we disbelieve her version?
No, that the question is that we have said that we are not involved in the matter.
Your saying doesn't matter, sir. Why have you to discard the evidence of the witness? You have to satisfy us. What is the motive for us, for her, to falsely implicate your clients? If your saying was relevant, no accused in this earth would be convicted ever. Who is going to confess? Probably you like Mr. Kamal to take over.
I'll take over. Then take over. Come, he'll satisfy you, lordship. We have prepared also.
No, that's your choice. We are not taking away anything from.
Yes, my lord.
Yes. Yes, Mr. Kamal, criticize the evidence of this witness. What motive did she have? PW2, she is the only witness concerned with the incident. Nothing else in the case.
Well, actually, the occurrence took place in the
In the dead of the night, it was dark. The witness stated that the accused was carrying the torchlight. The torches were not seized.
Yes.
All right. That is a usual argument.
Yes.
Turned down by Supreme Court in n number of cases.
But there are also judgments which goes in the favor of the
Yes,
accused also.
definitely.
Yes.
Because Supreme Court sometimes give both side judgment, my
Yes,
lord.
yes.
Who can find out what my.
Give us one suggestion to the witness, what motive she had to falsely implicate these two accused.
No, there is a motive that has been said that it is regarding the land dispute, my lord.
Have you taken that plea?
Yes,
in
my
your
lord, that is
313?
there, my lord.
Read, please. We have read it, we don't find it.
No, my lord. So far I remember it.
Read, sir, 313. Fortunately, this case 313 has been properly recorded.
Yes, my lord.
Otherwise,
Yeah,
we
yeah,
have found that the things are not good.
absolutely. Nowadays it has improved, my lord. We have seen it in the trial court, my lord.
Yes.
But even then we can find fault from the 313 also.
Yes. Read land dispute
Yes,
with
my
the
lord.
husband. Your suggestion is under the leader, page 52, under the leadership of Moina Mia, the witness of this case, Mokram Ali.
Page 17, if your lordship will kindly see,
Page 17.
17, my lord.
Yes, please.
Yes, we have written it.
Your 313 was at page 52.
No, no, my lord, I'm going first
Suggestion
from.
to the witness.
Yes, my lord.
Read, sir.
Last line.
PW2, my lord, yes. I read from the context, my lord. I have stated before the IO that the accused person are of
Yes.
release.
So
Yes,
land dispute was there.
I stated before the IO that there has been a.
That is the
land
motive
dispute
for you to
between
commit the
the
murder.
accused person and my husband.
Mr. Kamar,
Yes,
that is the motive. There is no suggestion that because of this land dispute, you have falsely implicated these two accused.
My lord,
This is-
sometimes
this is rather
without
counterproductive.
saying, with all respect, my lord, submit, my lord, sometimes without saying many things directly, my lord. Certain
This is
inference can also be
counterproductive. This
taken
gives
out, my lord.
gives an indication of motive.
No, my lord, it's not, my lord, it's one aspect, my lord. My aspect is that first thing, the prosecution has to prove beyond all reasonable doubt.
Yes.
That
So
I
the
am the
prosecution
person
has produced an eyewitness whose presence was absolutely natural.
No,
She had no motive to falsely implicate you. She has given evidence in no mean terms that no uncertain terms that these two persons came, they tied us up and they
Our
chopped my
contention is
husband to
that, my lord,
pieces.
we have been wrongly and misidentified. That is how I'll try
No,
to establish. my
where
case,
is that suggestion to the witness?
My lord.
Where is that suggestion to the witness?
Yes, my lord, actually, suggestion is just not evidence, my lord, because for evidence from both sides, section 3, if we read the lordship, my lord,
So
the examination in
you
chief.
want to discredit the
Yeah. My lord, by
version.
suggestion, if there is positive evidence, then there will be no requirement of suggestion at all, my lord. My
Yes.
respectful
All right.
my lord. Because suggestion are just to give up the build up the case of the defense side, my lord.
Yes.
Suggesting cannot be equivalent with the evidence. But if there is no evidence at all to connect me with the offense,
All right, you
then
satisfy,
I
sir.
go out, my lord. That is what
Satisfy
my,
us on that, sir. Very well.
that is what my, because PW1 and 2 was the only person.
Only persons present in the house, no dispute.
Now, my lord, if your lordship will see what are the other evidence that has been brought. The person who came immediately at the night time, my lord, what they at the first time said before them, my lord.
Very well.
Yes, my lord. That way I'll try to satisfy your lordship, my lord.
If you are not prepared properly, we can give you some time. Mr. Kamar,
I'll come back tomorrow, my lord, if your lordship permits
Not
me.
tomorrow, lordship.
Not-
Day after tomorrow.
we'll take it up in the next week then. Mr. Kamar, Chair
I'll
Counsel,
come
Mr.
fully.
Kamar, representing the appellates, please for some time to prepare and argue the appeal. List after 1 week.
Argument করছিল তো এবার না?
We'll take it up next week.
Sure, my lord. We'll come back to full preparation.
Item number 67.
এটা মূল নিয়ে
May I please? The petitioners, my lord, temporary working, my lord, is Sahayak, my lord, in Assam, my lord. Power Generation Company Limited, my lord.
Sahayak is not a post as such, Not an encadred post, we would say. So you are aggrieved by issuance of some appointment letters to 25 persons.
My lord,
That's what your case is.
my lord, since my lord, not a single judge, my lord, observe. Page 35, my lord. 11%, my lord, page 41, my lord, last two paragraph, my lord. Although, my lord, this rate petition was dismissed, my lord, there is observation, my lord, thus in future, my lord, if they take up the case for regularization, my lord, and my lord, then we may apply and if my lord age bar, then may apply for continuation of delay, continuation of age. My lord, since my lord last 20 years, my lord, they, my lord, one by one, my lord, appellant, they are, my lord, removing, and my lord, they are taking up, my lord, new incumbent, my lord, new temporary.
That is not your case. That is not your case in the writ petition, sir.
Although, my lord.
Your case is that there were 114 vacancies and they selected 25 only. That is your case.
Yes, my lord.
So that is their choice. How many to fill up? Is there a mandate that they must fill up all the vacancies simultaneously, even if they don't need it?
That's right, my lord, but my lord, post, my lord, is a permanent post 114, my lord, and is a requirement of permanent nature, my lord, but there, my lord, adopting different tactics, my lord, there, my lord.
This was not an advertisement for a permanent post.
That's right.
Is Sahayak an encadred post? Under what rules is it encadred? Let us know.
You lordship right in that aspect, my lord, but my lord, if the requirement is the permanent nature, my lord, last 12 years, my lord.
Is that was your writ petition for that purpose?
My lord,
That they should make a selection on permanent basis?
My lord, we were selected, my lord, but they fill up only.
They filled up 25, they needed only 25. That is why they must not be having the resources to appoint 114.
That is one aspect, my lord. Other aspect, my lord.
Is the fact that these electric companies, they are all running in huge losses. That is across the country that is happening.
That's right, my lord, but my lord, from their communication, it is apparent, my lord, this, my lord, permanent vacancies are there. 140.
Did you seek a direction that the permanent appointment should be made?
Yes.
Where is the writ petition? Let us see the prayer.
Prayer, my lord, page 95.
Read please 45.
95.
95.
90.
Let's read your prayer in the writ petition, please. You have only prayed that unfilled vacancies should be filled up. That is your only prayer. Not. But then the interim prayer is not to initiate any fresh recruitment process. So they have curtailed their exercise. What is wrong in that, sir? There's nothing in this appeal. Any legal argument, if you can advance, please do that.
My lord, so far they, my lord, filling up the post of 25, my lord, that's right, my lord, because they, at that point of time, my lord, advertising.
You were arguing that they should have undertaken an exercise of filling these posts which are permanent in nature. That is not your case in the writ petition. We just requested you to read the prayer clause. There is no such prayer. Your only prayer is 132 advice, please fill in everything. They don't want. Can we force them?
My lord, but my lord, if the, my lord, the posts are in permanent nature, my lord, they should, my lord, fill up. Otherwise, my lord, there is exploitation, my lord, because, my lord, they are removing us and they are taking.
Sir,
leave,
we will not go beyond the scope of pleadings in the writ petition. That is not your case in the writ petition. We are time and again saying so.
It's right, my lord, we have.
So settled law, even if there is a reserve list, it can't be kept pending indefinitely. Supreme Court says so, even in a regular selection. So they want only a particular number of employees. They have done that. Thank you. Dismiss.
There may be direction, my lord, but to take my lord, initiative, my lord, to fill up.
No direction is required, sir.
Because my lord,
We don't
problem
even
is
know
not there.
what has happened after 2011. Have you brought that material on record? What has happened after 2011? We don't know. Everything is in a state of uncertainty.
But my lord, we have instruction that they have not filled, my lord.
So they have not filled. That's their choice. They don't have money to pay the salary of the regular employees even. Okay, thank you. Dismissed.
Okay.
Item number 68.
Last question, Lordship directed whether the police verification, what is the up to date of the police regarding appointment.
Last occasion, sir, we don't have that kind of
14
photographic memory Mr. Chaudhary has.
14 post of malaria officers were advertisement in the year 2012. When
What is the fate of the ACB case?
that government will be able to.
My lord, in fact, we learned
Well,
on the last occasion, my learned friend made a
I'll
very.
submit your lordship.
I'm not making any submission. Last occasion, lordship posed a question, how many applicants participated in the selection process? My learned friend said about 56. That's a very wrong statement, my lord. In such a sensitive matter, such statements should not be made. My lord, total number of 938 candidates, my lord, participated in this selection. It's not all right.
Just hold on. Yeah, please briefly recapitulate what is the matter. The investigation is still going on. 2016 FIR. When will it end? In this century?
I think that that's part of the department. So if I have
My lord, if your lordship would kindly have a look at the impugned judgment.
Just give us a brief outline, please. What is the matter about?
It's my petition.
Yes, yes.
Advertisement was issued on 15/12/2012. That your lordship will find at page 51.
For
51 for 14 post of district malaria officer.
14
post of district.
Then what
malaria
happened?
officer. And it says, well, only one paragraph I leave, page 53. If the number of applications received are large, the commission may shortlist the number of candidates either on the basis of their marks obtained in the qualifying academic examinations, page 53, or by holding written examination. So they have gone for written holding, for holding of the thing by written examination.
Shortlisting.
So
Yes.
written examination was held and scrutiny, and the results were declared on 21/8/15. That is at page 57. So thereafter, my lord, the petitioner got a telephone call from one Mofidul Islam.
Yes.
My lord, saying that, my lord, during that unless you pay some amount, you will not be selected. So thereafter, my lord, selection was made, the results were declared, and the petitioner, on the basis of the written test, my lord, petitioner was selected for Viva voice test. And thereafter, my lord, results were declared without taking into consideration the marks obtained in the written examinations.
Without taking into consideration
the marks.
That was shortlisting.
Shortlisting, but marks, they are supposed to take into consideration the marks in the written
marks of shortlisting examination, how they will be taken into consideration?
That is what I find in the rules when.
Let us see, sir. What was the, for what after shortlisting?
I'll be brief in my submission. Rule 27, your lordship will can listen.
So the final selection was made only on the basis of Viva was a mark.
Viva was test.
Is that permissible?
That's fine. That's the rule says.
But the record will show, my lord, 50% on the basis of the qualifying marks.
Qualifying marks would be in the qualifying examination.
Well, I'll show, my lord.
Let's see the rule. You are who's for the APSC?
No.
So there. Rule is
27, your lordship will can see.
where a large number of applications are received as a result of advertisement, the commission may shortlist the candidates on the basis of their marks in the
So marks secured in qualifying.
qualifying examinations required for a post in terms of advertisement. The commission may thereafter call for interview, educate numbers of eligible candidates in order of merit, keeping in view the existing reservation policy of government. This is on the basis of the qualifying. There is no problem.
Alright.
my lord. Now, second, my lord, paragraph 28. 20, rule 28, sub rule 3, my lord. The commission may also hold written examination.
May hold.
Yes.
Yes, for shortlisting.
Shortlisting of candidates for interview.
Yes.
This is all, my lord. Now.
Where is the final
commission-
criterion of
29,
selection?
my lord. That is all is permissible. The commission may determine the qualifying standard by giving weightage on academic merit, subject knowledge, additional relevant qualification, service experience relevant to the post for preparing the final order of select list. Now, para 30, my lord, rule 30, in the Viva Voice test marks shall be allocated as below. 50% on academic professional qualifications, service experience relevant to the post preferential qualification, and 50% for subject knowledge and general bearing. Out of this, 20% shall be for the subject knowledge and the remaining 30% for general bearing. Now, 67 year lordship, can you see? 67. Married man. After completion of the interview personality test, the marks obtained in interview personality test shall be added to the marks obtained by the candidates in the written examination.
Yes.
Thereafter, on the basis of total so obtained,
Merit list shall be prepared.
merit list will be prepared. Now, 72, your lordship, you can see, the provision of rule 67 shall apply to direct recruitment cases also, so far as preparation of mark sheet is concerned. Now, if your lordship sees the marks here, I'll be very brief, my lord. 50% marks they have given on the basis of the academic performance. 20%
That is a qualifying marks. Qualifying
here at the time of final selection list,
the 50% on the basis of
on the basis of the academic professional.
academic.
Professional. This is as per rule 30.
Right.
Yes, 50% on academic professional they have given.
So the 50% is based on what marks you secured in your qualifying examination.
Qualifying, my MSc, MA and all those.
Yes.
things. And out of this, 20% shall be subject, next, my lord. 50% for subject knowledge and general knowledge.
This was regarding the oral viva was 50%.
Yes.
Yes.
20% shall be for subject knowledge. And the remaining 30% for general bearing.
Okay.
Now, if your lordship looks into the records, I have stated in paragraph 3 of my additional affidavit.
Yes.
All erasings are there in 30%. That is because when
Final evaluation has been done, whether the written examination marks were not taken into account.
No, it was not taken. Your lordship sees the record. I'll show 2 loopholes, my lord.
Let's see whether record is there.
Lordship, that photocopy of the record is available, that the original has been taken by the police. Sir.
We'll have to call the original then, Mr. Das. IO has
It
to
was
be here.
produced before the court. It was produced before the court. My submission is this, my lord. Written examination marks, they have not added. 30% marks, all overwriting. It shows, my lord, some conversation was going on, but unless you pay, your name will not be written.
Chaudhary, how can you justify
And
the
50%
final preparation of result only on the basis of viva was?
My lord, I'll answer it
Which rule?
one by one. My lord, what had happened in this case? According the premise on which the writ petition has been structured is the petition.
Call made.
Call on, my lord, 16/8.
Forget about that. Now the allegation is we ignore the delay and everything. 2 things you have to satisfy us.
yes.
First, how the evaluation could have been done only on the basis of viva.
It is done in terms of rule 28 and 29.
No.
Yes, my lord. Kindly see. My lord,
Yes.
you have participated in the selection process.
Yes.
Now the grades are
rules-
sour.
Rules say.
My lord, will kindly permit me to make one submission. my
Yes.
lord. When we were appointed, my lord, we were appointed at the cost of some 3F appointees. This writ appeal is nothing. It's a proxy litigation at the instance of those 3F appointees.
It doesn't matter.
No,
They
I'm
have
saying-
participated.
Ah.
They have, the appellant has participated.
Now the learned single judge has taken care of each and every argument of my learned friend.
Mm.
And learned, please come to the impugn order for one paragraph, my lord.
Yes.
If your lordship will kindly come to page number 138, my lord.
So remaining silent would not correct the record
All right,
position in
let
record.
us deal with it, my lord.
Yes.
Now, para 23, my lord. After dealing with all the allegations at 139.
No, interpretation would be required whether the evaluation could have been done only on viva voce.
No, no, my lord, the rule is very specific.
No, we are not
No,
satisfied.
rule 67 doesn't apply here.
Why
my lord.
not?
Huh?
Why not?
Not applicable. I'll
Why not?
explain, my lord.
Tell us,
Yes.
please. The commission's counsel has to satisfy.
My lord, that rule 67 is for, my lord, competitive examination, CCE.
This is
This is not for here, my lord. You cannot read one here and
Let us see the advertisement first.
Yes,
Where is the advertisement?
advertisement is at
page 51. ma'am.
51.
Yes, let's see.
Assam Public Service Commission invites application from Indian citizen as defined in so and so. Candidates should be within the age range. Application form are obtained from the issue and receipt section of the so and so. The last date applications are signed by the candidate and accompanied ahead of the account so.
There is nothing in the advertisement which says that the recruitment will be made only by viva voce. Nothing at all.
Yes, please come to page 53. my
We have seen it. That is for shortlisting.
When if the number of applications
Yes.
received are large.
So how many were the
commission
applicants?
may shortlist the number of candidates either on the basis of the marks obtained. in
How
the
many were the candidates?
My lord,
How many were the candidates?
963.
And how many were subjected to interview?
Eventually, my lord,
Only 56 against 14 posts.
14 posts
Okay,
in the ratio 1:4.
okay. Hmm.
Now, my lord, the advertisement is in sync with my lord 28 and 29.
Hmm.
Then, my lord, or by holding written examination, which will be notified in due course.
Hmm.
In case of single post, now 14 posts are advertised.
Hmm.
Then my lord will kindly come to the rules.
Hmm. All right, we'll continue at 2.
My
Daily list for orders, item 1.
Yes, please.
My lord, council is joining through VC.
Okay, let him join. Is there anyone?
Yes, my lord.
Yes, please.
Look, this is a matter which is a review
Hmm.
where the short principle, in fact, is that if people have been absorbed in a new service, then their past service cannot be taken into account in case there was no parity of service in the new employment with the old employment. Here they were taken on higher pay scales, and therefore we are saying that they can't ask for parity with the old service where they were getting lesser pay scales.
Yes.
That in fact is the issue in the present review.
Okay, please point out from the impugned judgment, the judgment under review, what is the flaw which you seek for rectification by way of this review?
Right. So there is 13,919 is the judgment of the Guwahati High Court.
Yes, ma'am.
And my lord, what it is relying upon is an OM dated 10th February 2000.
Yes.
That OM, we have no difficulty. We are also happily relying on the same. It's the interpretation of it which we are questioning. So there was a earlier judgment case known as Kushal Sharma. In Kushal Sharma, employees of the High Court were absorbed in CAT or vice versa. But they have been having equal pay and equal salary. Therefore, if they'd been having equal pay, equal salary, then their past service could have been taken into account.
Very well.
But my case is that drawing analogy from Kushal Sharma, the application is incorrect in this case. These people were working in for the government service, and then they were taken in the ESIC hospital at Bentota.
Right.
While the ESIC Bentota, they had a higher pay scale.
Okay.
So the pay scale that they were getting in the state government
As per you, there was no occasion for a career progression as they already were placed in a higher pay scale. That is the argument.
That's the short point. That's the short point before your lordship.
Yes.
There is a wrong concession by counsel which was made. I'm saying even that can't be binding on us.
But they already upgraded by virtue of the new placement.
Open the authority.
But higher pay scale in the Oh, that is just it. Yes, wrong concession. Yes. No, that's true. That's true. Yeah. Yes. What do you say? Yes, please. Perhaps we can restore the writ petition and hear it again.
Yes,
My lord, the basic contention which has been raised in the review petition is that the concession that was given, your lordship may kindly come to page 23 of the writ petition.
Yes.
Sorry, review petition.
The argument is that since the employees were placed in a higher scale of pay pursuant to their shifting into the ASI hospital, there's no question of grant of ACP.
Yes.
That is what the argument is. And logically, that seems to be appropriate.
No, my lord, that is not factually correct. And apart from that, the basic circular based on which this submission is being made, that was set aside by the CAT long time back. And that is why, my lord, the concession was given before this honorable court by the petitioner's counsel. Your lordship will kindly come to page 23.
Right.
Paragraph 3. The applicants before the CAT initially served under government of Assam. However, subsequently on 1/1/2006, they were absorbed by ESI. Over a period of time, they were granted ACP. While setting aside the orders dated 19/25/10/2012 and 8/7/2015, the CAT observed that the said wares were issued on the basis of the office memorandum dated 10/2000, which was set aside by the CAT on 9/9/2011. This was long time back, it was set aside. in the case of Kushal Kumar Sharma and another versus so and upheld by this court in writ petition number 5454 and 5480. In the cause title, it is stated that there was no consideration of the office memorandum dated 10/2000 issued by the Department of Personnel and Training. Mr. Datta, while not disputing the setting aside of the aforesaid memorandum dated so, submits that the said office memorandum was set aside not on the issue raised in the original application, and therefore the CAT was not justified in passing the impugned order. A perusal of the letter dated so of the appeal papers goes to show that while issuing the said order dated so, reliance was placed on clarification number 6 and 29 of the office memorandum dated 10/2000. The subsequent order dated 8/7/2015 in turn relied on the letter dated 19/25/10/2012. While the office memorandum dated 10/2 had been quashed, the clarifications provided in respect thereto will have no consequence. It is immaterial
Were the benefits of ACP withdrawn on the basis of those clarifications?
Yes.
Can we see those orders?
Now, this 19/25/10/2012.
Yes, let's see.
That was the order which was challenged before the CAT.
Page number.
That is at page 92.
Yes, absorption of state government employees in service of ESIC.
Yes.
No, this is 6/8/2008. Then that is 92 years.
92. Please refer to your office letter on so. Second paragraph, with reference to your second letter dated 23/8/2012, along with which representation of so is forwarded. From
So
representation.
the logic in this order is that you have been absorbed on a higher pay scale. The concept of MSCP is financial upgradation. On a stagnant post where there is no avenue of promotion, you get the financial upgradation.
Yeah.
Now herein you have also already got the financial upgradation.
Now,
So how you can be granted further ACP?
Now, my lord,
That will be giving a dual benefit.
my lord, here altogether more than 50 employees are involved in this repetition. And it is not a matter of fact that all went or each one of them went on higher pay scale. That's incorrect statement on record, my lord.
So then let us examine the merits of the matter once again.
Question is that, my lord, in the garb of this review petition, whether this honorable court will reopen the discussion for
Apparently, it seems to be from what example has been given before us, this order page 92, what you're sitting.
Yes,
The
page
the upgradation is already there.
Now the basis of this upgradation, the basis on which they are trying to deny the benefit, that is 10/2000, which was long time set aside. And that order went through.
Where is the MSCP circular? Let us see that then. We will have to go to the MSCP circular then. That's scheme.
In that case, my lord, my respectful submission would be, your lordship will be entering into the merits of the writ petition, which is closed by now.
Yes,
And
closed.
these
The review is based on a wrong concession. We can very well reopen the
Now,
things.
what is the concession? Concession is the 10/2000 was set aside. Now,
Yes.
your lordship will kindly see whether it was indeed set aside or not. Now, if they have filed an additional affidavit, my lord, and in the additional affidavit, they have closed the order of.
Madam, one issue which will rise, of course, is that your order is based on 10/2/2000.
Yes.
It's a fact. So your order being based on a non-existent circular, how it can be sustained?
My lord, it's existent. That also is a wrong noting by the court.
How do you say? From where?
My
where
lord,
is the
that
opinion?
circular is very much in, continues to exist.
Let's
And there are, I have shared with the court some 10 judgments
No,
of.
judgment is a different thing. Madam, where is your
No,
pleading in the
where
review?
that's-
Just please bear with us. Where
Yes,
is your pleading in the review petition that the circular dated this 10/2/2000 still exists?
My lord, it exists and I'm showing you the circular.
Will
Your
you please
lordship
read,
will first-
Madam, will you please read the pleading in your review petition?
Okay, very well. Just,
All right, para 4, page 8. Yes, Mr. Datta.
Yes.
The specific pleading that circular has not been quashed.
Now, therefore, your lordship will kindly verify with the record whether this pleading is correct or not. Your lordship will kindly come to the additional affidavit filed by them, page 22.
They say that there is no reference of that OM in Kaushal Sharma's case. Let us see the judgment in Kaushal Sharma. As simple as that.
I'll take your lordship to that judgment, my lord. Your lordship will kindly come to page 22 of their additional affidavit. The judgment of the CAT in which it was set aside, that is enclosed there.
22.
Page 22 of their additional affidavit, my lord.
Additional affidavit in this.
In this review petition.
138.
It will be para 11 in that particular paragraph page. We find that it starts with, my lord. We find that this issue is no longer res integra. Law is right on this subject. The Honorable Supreme Court in the case of so-and-so and so-and-so clearly laid down the position of law which is binding on all courts under Article 141 of the Constitution of India. Besides the SLP which was filed in the case of Union.
Please come to page 199, madam. Where from we get this fact that the circular still survives?
My lord, I'll just tell you. Lord.
Please read 199.
Yes, I'm just.
Yes.
My lord, I think there's something wrong with my paging, but will your lordship look at the
There
circular?
is the judgment in Kaushal Sharma. We are reading judgment in Kaushal Sharma, the last page. Scat judgment.
Yes.
Yes.
It's internal page 22, my lord. I'll just read
Yes.
it.
Yes.
Find that this issue is no longer res integra. Law is right on the subject. Honorable Supreme Court in Ramchandra versus Govind Vallabh clearly laid down the position of law which is binding on all concerned under 141. I'll show that judgment also. I've given the compilation. Besides SLP, which was filed in the case of Union versus so-and-so, we are of the opinion that the service reckonable for the purposes of ACV, it will include the period during which applicant was working with the state government. Accordingly, we set aside and quash the impugned DOPT letter dated 10-2, direct the respondents to grant second financial upgradation to the applicant 8-12 and to the applicant 3-6 with arrear monetary in terms. Now, what had happened? So, my lord, what I'm explaining is in Kaushal Sharma, the difference was, and they don't really set aside 10-2000 because Kaushal Kumar Sharma was a case where the persons had joined the establishment of the Gujarat, earlier the Guwahati High Court, and then absorbed in CAT on 1/11/89 on the same pay scale.
Same pay scale.
Whereas, so this judgment is not really the ratio for this case because here they were absorbed at a higher pay scale. So, my lord, the Ramchandran judgment referred to of the Supreme Court says exactly this, that if it is same pay scale, they'll be entitled. If it is a different pay scale, then it will not, they will not be entitled.
Which
Now,
judgment are you referring to, please?
Just hear us in detail after allowing the review.
Alert from system server, low battery. Alert from COM Apple battery monitor.
Sorry.
Okay. Where is the judgment you are referring to?
My lord, Ramchandran, just shoot. My lord, I had given a compilation to your lordships. It is M. Ramchandran versus Govind Vallabh. The second judgment in my compilation, page 28, para 12. On page 39.
Yes, page 39.
So it's really relying on Ramchandran, not of this circular. And the circular is on page 119 of the paper book. I'll come back to it. The circular has been upheld everywhere. We are of the considered opinion that sub-rule 2 of rule 5 is the relevant rule relating to the determination of seniority of the officer recruited to the service under sub-rule 1 of Rule 5, the seniority of such recruited officers is required to be determined with reference to the date of their regular appointment to the post. Now, my lord, if I skip all this and come to D, placetum D, length of service is a recognized method of, no, seniority is a relevant term having reference to the class, category, and grade to which reference is made. So that's why the moment a person is on a different pay scale, different grade, then and therefore, when they joined the hospital,
It's not a different grade, madam. It's a pay scale.
Depends. No, it's not different, but in some cases it will be different grade. In this case, it's a different pay scale. So the designation doesn't determine, it's the pay scale, it's the fact those people were in government service at 3450, and when they joined ESIC, they got 4,500. Now, if your lordships, if I finish reading this judgment, then it says it therefore follows total length of service is not relevant for determining seniority, but length of service to a particular class, category, or grade is relevant consideration for purposes of counting the period with respect to length of service for purposes of determining seniority. In other words, the period of holding of the equivalent post in the parent department would be the relevant period to be taken into note of for purposes of determining seniority under Rule 5.2 and its provisions. Any other interpretation would be against settled rules of service. Jurisprudence is
they've already got that. Yes, please.
A perusal of the rules does not in any way show, and rightly so, that the rule-making authority had ever intended to take away the benefit of length.
That is going on to the merits of the matter. First, you have to satisfy us regarding the 2000 circular still being alive.
It's still being alive. I'll just show judgment after judgment. So, my lord would just see first PS Rajput, which is serial number 8, page 103. At para 18. So the two relevant clarifications are clause 6 and 29 of the circular, which is February 2000. And the reference is made in para 16 and 17 on page 106. The citation, my lords, citation, 2019 SCC Online Delhi 7081. It's a division bench. Justice Singh. Then para 5 is referred if in para 16, and I can read it out for your lordships. Yes, and it's talking of the 10 to 2000 circular, para 16, if your lordship will see. Para 16, page 106.
Yes.
And the query is in para 5 and 6. In para 16, the 5 and 6 clauses about this circular, and the explanation and the clarification given on 10th February 2000. Para 18 is what says, a reading of the clarification shows that if the government servant joins second post again on direct recruitment, but the pay scale does not change, then his past regular service in the same pay scale, even on appointment of a different post, will be counted for computing the requisite period for the purpose of ACP. However, the appointment is made to a higher pay scale in the second direct post, recruitment post, past service will not be counted for purposes of ACPs. Now, Lord, same is decided by a host of other judgments of all the high courts. And I'll just show my lord one or two others. I think one is on page 110. My lord, it is Guwahati, no, this one. No. I'm just seeing.
Yes.
My lord, I have, no, and Union of India versus Rajeshwari, para 6 to 8. Now, it is page 117, just para 6 to 8.
Well, the situation, it boils down, madam, that some of the high courts, while deciding the matters, have referred to that circular. But the CAT judgment, which has been,
My
it has
lord,
not been upheld, it has not, there is the validity of the circular was not under challenge. It is not in so many words that the validity was being examined. It has been referred to, that's all.
my lord, I am not saying anything. I'm only saying the 10 to 2000 circular was clarificatory of the 99 notification. And
Yes.
both have been implemented High Court after. So in Kushak Sharma, which is the one judgment they are relying, 10 to 2000 circular was not even needed to be applied because the pay scale was the same. So it was, as I say, it was not relevant for that judgment. So any observation would not come in my way.
Mr. Datta,
Yes,
we are inclined to accept the review and hear the writ petition again.
Father, may be permitted to place one judgment.
Yes, please. You tell us on principles.
On
If there is
principle,
already a financial upgradation by the dint of change of service or absorption in a different service, can the employee claim ACP? The concept of ACP is stagnation at a particular financial
on
stage.
on principle, my lord, there cannot be, I cannot have
So
different.
that is what
But-
the scenario is in the present case.
but-
You will have the liberty to tell us in the writ petition that no, some of the petitioners or your clients, they were placed at the same pay scale despite being absorbed in the services of ACPs.
But the basic ground on which they are seeking review, your lordship will kindly examine that. Their basic ground of review that the concession was given, it was a wrong concession.
Yes.
Whereas they are quite silent on this aspect that these particular
See,
circular.
the High Court judgment, Kaushal Sharma, 2000 was never considered. 10 to 2000 was never considered.
No, 10
A
to-
passing remark by the CAT, that can't bind us, sir.
So, my lord, then this CAT judgment in Kushal Sharma, where 10 to 2000 was set aside. This judgment was upheld
Factual
by this
aspect,
honorable
can we ignore it when there's a specific pleading that all of your clients are getting a higher pay scale?
No, and the second aspect that I'll argue before your lordship is this.
You argue it in the writ petition. We are not
Whereas-
closing your rights as yet.
Whether.
It's only only review is being accepted.
Well-
Writ petition will be restored. You will have a right to address the court.
Well, that I'll be having my right, I know, my lord, but
Mm.
the question is that whether on this specious ground,
Mm.
that in some high courts, there were some discussions.
Forget about the other high court's observations for a moment. We are asking you on principles.
On principles, my lord, that is.
So then that all
cannot-
right, very well, then they have a right to argue.
But this very circular, which is the basis.
Ignore the circular for a moment, sir. We are again telling you on principles.
I leave it up to your lordship.
All right, review allowed. Writ petition to be restored and listed for hearing after 3 weeks.
Lord, would 25th be convenient to your lordship?
It will come up in September, madam, not in August.
All right. My lord, can I indicate the dates to the court master since I'll be coming from out of town?
Last week of September.
Very well, my lord. I'll
Yes.
give the dates to my colleague.
Yes, sure.
I'm grateful, my lord.
Obligement.
Item number 2.
Yes.
Lordship. Lordship, this is a case of Lordship compassion appointment actually. And Lordship, only my humble prayer is that Lordship. Basically, Lordship, appointed Lordship, there is no case at all.
You have to put him in Paris.
Lordship. Lordship, the father of the petitioner Lordship died in the year 95. And according to Lordship, her mother Lordship initially submitted an application to consider the candidacy of her mother. So the concerned department Lordship did not consider the application up to 2007. It was kept pending Lordship. Accordingly, Lordship, in the meantime, Lordship, this petitioner become major.
Is it a heritable right?
No, Lordship.
Then chapter closed, gentlemen. That is the answer of your.
Only Lordship, my only prayer is that Lordship.
Yes.
Since Lordship respondent has considered the all application who filed the year 1992 and application were considered in 2015. So Lordship, my humble prayer is that on the same.
What is the concept of compassionate appointment?
If Lordship, I'm agree
To tide over penury or save the
Lordship.
family from immediate financial
Lordship,
distress.
I am agree with all aspects, Lordship. The
Then-
only thing is that Lordship, since respondent has Lordship, may kindly come to page 63 of my review petition. Here, Lordship, since 1992 up to 2015, all application has been considered together.
Your mother had, if your mother had come and filed the writ petition being aggrieved of the non-consideration of her application, it would have been different.
Lordship.
The
But
first
if-
question we pose to you is whether this claim of compassionate appointment is a heritable right.
No, Lordship, I agree with your Lordship. Lordship,
Thank you.
Lordship, may I say one thing, Lordship, only one thing, Lordship.
Yes, please.
Lordship, coordinate bench of this honorable division bench, Lordship, also rejected the prayer of the similar matter. But Lordship, one observation has been given that since Lordship, his application never been considered, let
Application of the mother. That was the application which could have been considered, not now. The time gap is too much, sir. This very prayer is against the principles of compassionate appointment.
and also Lordship against Article 14, Lordship.
Yes, Article 14, compassionate appointment, is it a right?
That is not a right, Lordship.
Then-
But
then
since Lordship,
There is no
Article
question of
14
Article 14 coming into picture. If there is no right, then what is the violation?
Lordship, they are still Lordship appointing who have applied in 1990, still appointing Lordship. Only my prayer, Lordship, since my
You
application
file a
never been
PIL against that. Thank
Lordship,
you.
kindly one
Rejected.
line may be considered, Lordship.
Thank you.
Lordship.
Dismiss.
Of that, Lordship.
All right.
May present.
Yes,
Sorry,
please.
sorry to bother.
No, no, it's okay.
Lordship, item number 57, we had filed, our intervening application was allowed on 1/6/2023.
Item number
57.
57.
57.
Yes.
Our intervening application was allowed on 1/6/2023. However, our name, there was no direction to add us respondents, Lordship. Our pleadings have not been accepted now.
But you have been allowed to intervene only.
Yes, sir.
So your name will not be there in the cause title. Maybe it can be incorporated as an intervener.
Yes, Lordship, our pleadings are not accepted.
Fine, if the order has not been signed, we'll do the needful. Just point it out to me. We'll do it. We'll mention that you will be allowed to file
Yes,
your
yes.
affidavit.
Yes,
Okay.
yes, Lord.
Where were we?
Yes.
68.
My lord, Lordship will kindly give me 10 minutes time. I'll just please whole case. Now, my lord, my learned friend from
Mr. Chaudhary, before you proceed,
Yes.
would like to know, this is a bunch till 75. 68, I don't know, 68 is an individual matter.
single matter.
69 to 70.
Yes.
Okay, okay. Yes.
Now, my lord, from time to time, my learned friend is arguing different points. Now, first of all, let us see what was his case before the learned single judge.
Okay, okay.
Now,
Very well.
please come to the writ petition, my lord.
Hmm.
His basic case is
Hmm.
that, my lord, he got a telephone call. And based on the telephone call, he lodged an FIR.
Hmm.
And therefore he suspects that everything is fishy. Now, the learned single judge, my lord, while dealing with all the legal points he has dealt with it. And regarding the criminal case, what the learned single
Ms.
judge,
Chaudhary, from what we could gather from what he was arguing, the only issue which requires deliberation in the appeal is whether the selection could have been made based on viva voce marks only.
this was never argued before the learned single.
This was never a
Never
ground.
argued. It was never his case.
It was a ground in the writ petition.
No.
No, this was argued. Then single judge has observed based on Ajay Hasia.
Ah.
That observation is this was argued.
Ah.
You
No,
don't
no,
say
no. Well, Ajay Hasia, he placed on a different perspective.
No, this was precisely the argument.
Yes.
Just come to the single bench judgment.
No, my lord, his argument was, how come the mark is more?
No, no,
It's
no.
not that selection could not have been made.
Just come. Just come to the judgment.
Yes.
Para 3.
Yes.
First,
Challenge made to the
APSC is-
APSC. Firstly, APSC had prepared only on the basis of marks obtained by the candidates in the viva voce test by ignoring their marks in the written test.
Yes, so that is the first argument.
Yes.
Okay.
Now, my lord, according to the petitioner, they had the final select list prepared on the basis of the aggregate of scores of written test as well as viva
And the
voce.
second argument is regarding their practices.
Yes.
So we are not going on that
Okay.
for the timing.
Okay,
Let us come to this first aspect.
Please come to the, my lord, rules. Yes.
Rules, APSC.
Yes.
Can we first have a look at how the learned single judge has dealt with this argument?
Yes.
Para
Let's come to
5.
page 134, para 10. Chapter 3 of Rule of 2010 deals with the procedure for direct recruitment. As per Rule 21(1), chairperson of the commission is required to constitute the board for interview viva voce of candidate for various posts for which selection is to be made. Rule 23 provides that program for interview shall be fixed by the chairperson.
Okay, so you mean to say that the clause 69 which they were reading,
Yes.
that deals with the combined competitive
That is in
examination.
Chapter 4. The different thing altogether.
My lord, your lordship will see 72, my lord. I also read 72.
Have you got, all right, Mr. Das, we put you a straight query. Have you got any judgment wherein this Guwahati High Court has dealt with this aspect?
Yes.
That the selection based only on viva voce is bad in the eyes of law?
Yes.
Any judgment of division bench?
Selection, my lord, selection, if your lordship sees the record, last time when the record was produced, there was override.
Don't go on that, sir. First, we are on the aspect whether selection based on viva voce only is permissible. Then we will go into the aspect whether the marking.
Record will show 50% marks were given in their interview and 50% what is written in the, my lord, judgment. The big difference is there because the record shows different. Record shows, my lord, 50% marks given on the basis of the academic marks, 20% on technical and 30% on the general aspect as per Rule 29. So therefore, the 30% marks which have been given, my lord, your lordship will see that 30% marks, a lot of overwriting is there in all the column.
Overwriting arguments are different, entirely different
For that,
ball
your
game, sir.
lordship will need the
First,
record. Yes. My lord, and for the other purpose that marking and all, my lord, even 20% marks on a viva voice test is bad. Supreme Court has held, my lord. My lord, even my lord, here 50% marks has been taken into consideration.
so
for viva voice.
that ratio or proportional fixing of marks you did not challenge before participating. Will not allow you to challenge it now.
No, before participating, nothing was there in the.
Now the rule reads.
No,
Rule by itself, Rule 30 says so.
Rule also says, my lord, at 70, Rule 72, your lordship will see. For direct recruitment, written marks. has to
Now,
be
what is
able-
the stand of the commission regarding the evaluation process?
And
Whether it can
my lord,
only be based on
your
viva
lordship
voce.
has heard this. My lord, second aspect of the matter, I would like to add, my lord, this will be my brief submission before the court. My lord, interview was taken by one Basanta Dole. And the Mustafa, that person, Mofidul Islam, he gave a call. Now, Mofidul Islam has been charge sheeted in another APSC case. Lordship may not do it, my lord. At the same time, Basant Dole, my lord, person who took the interview, he is also charge sheeted in another APSC case. Person who takes interview, my lord, they must be a very, very clean, my lord, character. This is another Supreme Court judgment is there. So your lordship will take into consideration. I'll place the Supreme Court judgment. Your lordship will see the record first. See the record, how the overwriting is there. And pace, the rule 72 says, my lord, rule 72. Rule 72 says
67 would apply to direct recruitment as
provision
well.
of Rule 67 shall apply to direct recruitment cases also, so far as preparation of mark sheet is concerned.
But that, you see, it's combined competitive examination.
No,
After
this
the
is a-
shortlisting,
this is a
just
different
hold on.
chapter 5.
Hold on, sir. In the combined competitive examination, there are two stages of written examination.
My lord.
First for shortlisting and then the final examination.
Yeah, there-
So that the final examination marks, they have to be accounted for.
Yes.
Herein, there is no such process.
But it is-
Herein, the written examination is mentioned only
For
as,
shortlisting.
only as for shortlisting. So
That I understand.
shortlisting marks,
Yeah.
you
But
see.
at the same time, my lord, your lordship will see the record.
Mr.
Your
Das,
lordship is satisfied, my lord, I have nothing to say. Two
Mr. Das,
aspects of the matter.
shortlisting exam, if the marks were accounted to be accounted for, the very exercise would become redundant.
No, that's
There-
what I was.
Yes.
That how the marks were given. my lord,
How the marks were given,
Your
let us
lordship will
see.
see the
Let us see whether there is an argument on this aspect.
But these marks were reproduced before the court only at the time of hearing of the case. And this honorable court directed, my lord, who has initialed in the overwriting.
Is the original record available? Let us see the photo state then. All right. And there was a single member conducting the interview.
The interview,
No.
two members were there. Two members have given marks. One is Basan Dole, he is charge sheeted in another APSC. They all do
There
it
is
on
nothing in
different
the
purpose.
record, nothing on the record
Yes.
regarding your so-called charge sheets.
And all the, my lord, overwriting in the marks given, my lord, your lordship will see that. We have filed it in the additional affidavit before this court.
What you have filed?
Yes, we have filed showing, my lord, how the marks were allotted. Your lordship will take the views of the.
Let's see the Viva versus sheets. Where are the sheets?
Last time when the matter came, your lordship directed that who has initialed it? Overwriting on the basis of all these phone calls.
Initials are there. Who we can't say.
Yeah, my lord, that was what was directed. And why did all this overwriting, my lord, in all the selected candidates?
Overwriting is by BK Dole. The signature initials are by BK Dole.
Yes.
That we can.
Person,
clearly
that person who has been charge sheeted in
Yes.
the case. We have shown in the affidavit filed by before this meeting. Not believable, man.
Just one moment first. Well, then we'll have to have one affidavit from the commission, whether the selected candidates are only those persons in whose cases there has been an overwriting in the result sheet. Let us examine, test it on that aspect.
Lots will have that. And regarding that procedure,
will
my
ask
lord,
you,
there is
just-
a judgment, Supreme Court has upheld this, my lord.
What?
The Anjara Ahmed's case, where 50% was for academic marks, 50% for interview.
Forget about it. Now let us come to this. Just tell us names of your clients.
Yes,
Is Dhrubajyoti Chaudhary selected?
1 second, my lord. Our candidates are,
Dhrubajyoti
no, my
Chaudhary.
lord. Mojidul Islam,
Yeah, Imdadul Islam Khan.
no, Mojidul Islam,
Just let us.
Orojyoti
We'll tell you.
Majumdar,
We'll tell you. Just hold on.
Orojyoti Majumdar,
Just a moment, gentlemen. These are all the respondents' numbers.
5 to Naina Bhuya to my lord.
Naina Bhoyan. So
Karang
right,
YP.
the overwritings are
That Chaudhary is not there, my lord.
Imdadul Islam Khan. Not there?
Not there, my lord.
We'll just tell you.
Not there.
We'll tell you. This is Durvajyoti Chaudhary, not there.
Not there,
Then Imdadul Islam Khan, not there.
not there.
Then Indu Bhushan Datta,
Yes, it is there.
70. Just
Hindu
hold on.
Bhushan
then.
Datta is there, madam.
70, then Imdadul Hasan also gets 70 marks. Why he is not selected?
I don't know.
70, then 75, then first 75, then 72, then cut to 70. 3 cuttings. Then there is Durvajyoti Chaudhary.
No,
There is a
not there.
cutting
No,
75
not
years.
not
He has been initially awarded 75, then cut and reduced to 70. So if there are 2 candidates on 70, why one has been left out?
That APSC will have to answer.
Yes. Keep some of your competent officer now present in the court. Then there is again Nilotpal Paul. He originally marks were 72. Cut.
Nilotpal Paul.
Cut
Yes,
and brought
he's
down 72, then brought down to 70. Nazia Hassan, 74 to 70.
Ghazia Hassan is not there.
And then maybe Sayyid Rizaul Karim.
No,
No, that is 71 to 70.
no.
All reductions. When were these reductions made? We don't know. And Ms. Chaudhary,
My lord.
very interesting thing is, we'll just pass on the sheets to you. In all these sheets, the chairman member has not signed. Except when we come to these Anirban Das mark sheets. Why there are separate serial numbers?
Anirban
Day-
Das is selected.
Day by day. Anirban Das is selected. He gets 69 marks only. So how he is selected when 70 marks candidates are left?
The academics marks he has high.
This total is after accounting for everything.
Okay. Maybe Anirban Das could be a scheduled caste candidate. My lord.
No, that is not mentioned.
No, my lord. Das may be a scheduled caste in Assam. My lord.
We don't know. We don't
Not
know.
all Das, like my learned friend.
SC, yes. SC, ST. Yeah, that's mentioned there. Yes. Then Deep Jyoti Sharma, 68 to 75. What a jump.
Deep Duty.
Yes, number 8,
Yes, yes, Deep Duty is selected.
68 to 75. It is a blatant mistake. Absolutely. Jirsong Terang, originally 68, then 64, then 62.
No, he's not selected.
Hmm. That's what apparently it so seems. Apparently it so seems. Nibanita Boyan.
Yeah, my lord.
Yes. It is reduced from 64 to 60 and the cutting doesn't bear any initial. Then it is Mazedul Islam,
He is selected.
74 to 77.
He is
No
selected.
initials.
He is selected.
No initials. General bearing marks have been increased. This process can't be saved, sir. Absolutely. We'll have to record everything and then go by this. You know, the chairman's signatures on the different sheets are different.
Let my lord, as suggested by lordships, my lord, let APSC clarify their position vis-a-vis this, my lord.
Yes. So he must have been, he was very much there when this process was carried out. You have a look at the sheets. We are giving it the sheet. Now there is nothing secret. They are part of the chart sheet.
Yes.
Page 71 of the additional evidence. Chart sheet line.
You tell us about the fairness. Or else what we can do is, Ms. Chaudhary,
My
we
lord.
can ask them to provide photocopies.
Yes.
This is under investigation. All right, all right. But if they had asked for the copies under RTI, would you give it or not? RTI. You don't need our permission in RTI. Well, we'll make Mr. Mazumdar or amicus curiae. You are representing someone in this case. State. All right, we'll ask Mr. Mazumdar to assist us. The original record has been produced by Standing Counsel for APSC, Mr. Swanshu. Since the criminal case in relation to the selection in question is still in our investigation. On a perusal of the evaluation sheets, we find that there have been rampant cuttings and overwritings in the manner of awarding marks to the candidates. There are various other discrepancies which, for the present, we refrain from commenting upon. The photostat copies of the record shall be provided to Mr. Mazumdar, the Additional Advocate General, who shall prepare a summary thereof for assistance of the court. Re-notify on. Record. We already mentioned. It will come up on a particular date. Yes, yes. 21st or 22nd.
My lord, for our preparation also, we will have a copy. Informally,
Still informally, all right. Give copies informally. But informally, Mr. Chaudhary, it becomes difficult. If it goes out, then the sanctity of the investigation.
My learned friend has already filed an affidavit.
No, from here we have seen, my lord.
So
So affidavit, we will allow you to inspect.
Yes.
Inspection from.
Yes, we'll inspect.
No phone to be used.
No photo.
No phone to be used. No photos.
Nowadays, that is the most
Yes.
lethal weapon.
We saw the record from here. my lord.
Both of you allow the record, both the senior counsel peruse the record, and Mr. Mazumdar will prepare the summary.
My lord, instead of 22nd, could it be 23rd, my lord?
Very well. 23rd. Now, every day is a hearing day.
No, some more matters than 22nd.
We will rarely find a day on which Mr. Chaudhary is free, except probably when he is on vacation.
Item number 69 to 75.
May pleases your lordship. In this case, your lordship, R. Mazumdar is appearing, your lordship. He is on the legs, your lordship. Kindly
is the
pass over the
controversy?
matter for time being.
My lord, this is a case where BEd is not prescribed for, my lord, assistant headmaster and vice principal. Otherwise, BEd is required for all.
All.
In fact, lordship will recollect on the last occasion, we have produced a letter annexing in the affidavit where the secretary requested the government council to recall the affidavit and file a fresh affidavit.
Your lordship, pertaining
In
to
fact,
the
my lord, the prescription of the NCT is also that BEd is a must.
BEd is a must.
They have filed an affidavit which is on record.
Your lordship, perusing to that last order dated 26/7/23, your lordship, we need to obtain instruction, and your lordship, instruction has received, your lordship.
Has been received.
Yes, your lordship.
What, do you want to file something on record?
Your lordship, your lordship produced it, your lordship. So kindly pass over the matter for time being, your lordship.
Some other day, my lord.
Yes, jointly re-notify on 29th August.
Yes.
Deeply obliged.
In respect of item 68, my life, I'm sorry, I forgot to mention my name. My name may be reflected. Otherwise,
Name of Mr. Mazumdar, Mr. D. Mazumdar shall henceforth be reflected in the court list.
My- deeply.
আমার আসিস না তো হইল না
Item number 76 to 84.
Yes.
On the last order, your lordship has directed the respondents to submit counter affidavit. Just yesterday, they have, my learned, AGS submitted.
What is the controversy? Can you briefly tell us?
I want to give the reply of the counter.
We'll give you the time. Just briefly tell us what is the matter.
The issue is regarding that conversion, lordship, surveillance quota becoming LDA.
Oh.
And we have reverted them back.
Mhm.
And
You filed something yesterday.
yesterday detailing because they are accusing individual cases, lordship.
Okay.
So we have given a detailed affidavit. And also I'd like to make my submission whether what law was prevailing at that point.
All right.
UKNIL was also here, lordship.
Ms. Saikia, the counsel for the appellant submits that a fresh affidavit pleading has been filed on behalf of the state yesterday. And thus, we need some time to go through the same and respond if so required. Re-notify. Now it goes to September on 20th September.
Lordship. Highly obliged.
20.
20 lot.
20 must have.
Item number 85.
I need some accommodation for today, my lord, in this case. Because
Purka has raised for time to argue the matter. List after 4 weeks.
obliged, lordship. Increment may continue, madam.
Interim order shall continue.
Okay.
My lord, the date may be fixed, my lord.
Let it come upon then 14th September. List on 14th September as per interim order shall continue.
Item number 86.
May I please, lordship. Lordship has already heard this matter, lordship, regarding the default, lordship.
Default.
Yes, lordship. Lordship has already expressed that the orders may be go.
The
Private, last occasion, the government has placed the.
has placed that he is in default.
Default.
Yes.
My lord, actually, I'm appearing on behalf of respondent number 1, and we have just filed affidavit today. So kindly grant.
Council MS so appearing for the respondent number 1 submits. Respondent number 1.
Yes.
Last
State.
occasion, government has, council.
That he has filed an affidavit on behalf of such respondent today or yesterday.
Today.
Today. The same we brought on record, re-notify on 17th.
Lordship, before that, lordship.
17th August. Before that.
Item 87.
My lord, this is a matter, there's a dispute regarding a particular plot of land, whether it was acquired for the NF Railway way back in the 50s, my lord. Now, there is an order by the learned single judge, my lord, based on the report of the circle officer. Now, having found that the particular plot of land is in the occupation of the, my lord,
Railways.
NF Railway, therefore the order is either you pay, vacate the land or pay the compensation.
Compensation.
Against that, my lord, they have come before lordship, the appeal is admitted and they just stay order. Now, my lord, during the pendency of this appeal, 2-3 developments have taken place. Number 1, my lord, a survey has been conducted and we'd like to bring on record the survey map number 1.
Okay.
Secondly, my lord, another litigation was filed by the railway where the same plot of land is involved, where the learned single judge has again passed an order for my lord survey of the land to find out the veracity.
Okay.
So I would like to file an additional affidavit to bring on record both.
Senior counsel, Mr.
I'm praying for
Chaudhary.
10 days time, my lord.
Appearing for all the private respondents?
Yes.
For the private respondent submits that there are some important developments have taken place during pendency of the writ appeal, which he would like to bring on record through an affidavit, additional affidavit. 3 weeks time is granted for doing the needful. List of 3 weeks.
My lord, may kindly fix a date of
List on 15th September. Okay. 4 weeks time.
Yes.
Item number 88 at 89.
My lord, item number 88, I have urgency, but I have some personal difficulty also. I have to go to Shillong for some days. Tomorrow there is a meeting, my lord. May I pray, my lord, it will be taken on Friday, my lord. It will not take very long.
What is, which is this
Matter
matter?
relates to my lord, I am an elected president of Jila Parishad. Now issue is regarding withdrawal.
The
of-
one in which we passed the contempt initially and then
Yes.
same matter, yes.
Could your lordship be kindly please take up on Friday, my lord, or on Monday?
Monday rather
Or 17th, my lord, 16th.
16th.
Okay, I'm deeply obliged.
I apply, lordship. In respect of item number 86, they have today entered APS for respondent one. Lordship. They want to file affidavit, so lordship
So
has.
she said that she has filed
Yes,
affidavit.
Wrongly said, lordship.
Okay, she has submitted that she has put in appearance on behalf of the respondent number 1 today and would need some time to file an affidavit. List, so already, we already granted you time.
On 17, no?
Also-
Earlier several occasions, they have taken time, lordship.
Yes, so already we have given you time, file it on by 17th.
Yes, lord.
No problem. Very well.